Next, call the list. Yes.
Only the name of the state advocate has not been inserted, Your Lordship.
What is the name?
Nilay Chakraborty and Mr. Shagin. কোনো ব্যাপার না। এটুকু সাবমিশন করতে হবে।
Nobody has appeared here. There is no mentioning.
Not actually appeared, but somehow.
You are not given the name also. And then my order also does not record who is appearing for the state. So and this matter is listed as to be mentioned for correction in the order dated 13th May 2020.
If it is not in the order, then name should not come.
Counsel for the state submits that though he has appeared in the matter, but his name has not been recorded. Accordingly, in the cost title of the order dated 13th May 2025, name of Siri. What is the name?
Nilay Chakraborty, Shagnik Shankar Sikdar.
Nilay Chakraborty and so be recorded
একটা উপরে একদম তুলে রেখে দিয়েছিস মহাভারত করতে
as appearing for the state. This is next.
Mr. Nilay Chakraborty and Nomrata Das.
Here also.
The order is written last
So bring for no, the matter is listed as to be mentioned for correction in the order dated 14th May 2025. Counsel for the state submitted, though the state had appeared, but the learned advocate appearing for the state and the name of the learned advocate appearing for the state is not recorded in the cost title of the order. In view of the submission, we made the counsel for the state in the cost title of the order. Name of the counsel for the state, namely, name of Siri. What is the name?
Nilay Chakraborty.
Give in writing.
Yes,
To be recorded
we are giving.
as appearing for the state. Next.
Item number three, the name of the advocate. Wrongly.
What is the name of the advocate?
Instead of Procedural and Procedural.
Give the name. Where is the name?
Even in the first bed. Of the advocate wrongly.
आप पढ़ लेंगे?
कोर्ट के दिते बोलছে
आप पढ़ लेंगे? तो लेके आप क्या पढ़ रहे हैं वहां? The matter is listed as to be mentioned for correction in the order dated 16 May 2025. Counsel for the petitioner submit that in the cost title and paragraph 1 of the and in paragraph 1 of the order, the name of the counsel for the petitioner is wrongly recorded as Sandeep Bhua instead of Kumar Santanu and Mr. Kumar Santanu. Accordingly, in the cost title, in the paragraph 1 of the order dated 16 May 2025, the name of the counsel, petitioner shall be read as Kumar Santanu, Mr. Tayyab Sahadat, and Miss Nikita Paul instead of Sandeep Bhua and Sudeep Bhua and Sandeep Roy.
One more matter, the appearance of the parties are also not, I informed them to come to the.
Next.
Item number 4, opposite party number 2 has been recorded, name has not been recorded.
My petitioner's name has also not been recorded. And there are two other corrections, small corrections from it. And in paragraph 3, last line.
দাদা জশ সাহেবকে কাগজটা দিন
Another, namely, it should be Amol Shah. It has been written as Nitai Pada.
Where?
And Lordship,
Where?
in paragraph 3,
Paragraph 3, page number?
page number 2,
Page number 2. Instead of Nisai Padasa,
Amol Shah.
Amal Shah.
আমার নাম
Against the petitioner, namely Jagdish Shah and another Who is the Nitai Padasha? Complainant.
Shah is the de facto owner. Victim and.
Rakho na.
Amol Shah is the another.
His name is not here. Jagdish, oh. Sense suffering and the matter is listed as to be mentioned on the to be mentioned for correction in the order dated 14 May 2025. Counsel for the petition submit that. Who had appeared for the petitioner?
Only per minute.
But it is not recorded here.
I had appeared.
Counsel for the petition submitted, though the counsel for the petition has appeared, but is not, his name is not recorded in the cost letter of the order. Accordingly, cost letter of the. क्या बोला? Counsel for the petition submitted, Mr. What is your name? Your Banerjee appeared for the petitioner, but his name is not recorded in the cost letter of the order as appearing for the petition. He further submitted that in the order at paragraph 3, page number 2, last line. Namely, Nitya Pada Saha is to be deleted. Last line, the word namely Nitya Pada Saha shall be deleted.
Instead, it should be Amol Shah.
Deleted.
Well, opposite party number 2, Miller. Well, my name has not been recorded, Miller.
It is not there.
Miller, last time I appeared, Miller.
Maybe appeared.
Miller, your lordship kindly, Miller, both are appeared.
And what is the further correction?
Second, paragraph 13. Lordship.
Hmm.
Paragraph 13. Lordship, 14th line. Released on 4th of October 2010, it should be 4th of November. He was admitted on 3rd of November and released on 4th of October, it should be 4th of November.
3rd November 2010 release on
4th of
4th November. In paragraph 13, line number 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13th line, 13th and 14th line, the date instead of 4th October 2010, it shall be read as 4th November 2000.
Miller, kindly, Miller.
This order may be treated as part of the order.
My name has not been recorded. Last time I
Sorry.
appeared, Miller.
Yes, next.
Item number 5.
5 Miller. State advocates name are not recorded.
ये जितना करेक्शन वाला है ना, जितना करेक्शन हुआ सारा एक नोट बनाएगा, हमको फॉरवर्ड करेगा. आई विल सस्पेंड द पर्सन हु हैज टाइप्ड दिस. I want the report from you. How many matters have been listed for correction in the cost title of the orders for mentioning, and who has typed this order? It is not the work of the judge to see who has appeared. I will suspend immediately. Record. Item number 5. The matter is listed as to be mentioned for correction in the order dated 14 May 2025. The counsel for the state submitted, though he has appeared in the matter, but his name is not recorded in the cost title of the order dated 14 May 2025. Accordingly, in the cost title of the order dated 14 May 2025, name of Siri, give the name, be recorded as counsel for the state. Next.
Item number 6.
Yes.
Previous officers who have filed the exemption order.
Yes.
কাস্টমার নিচ্ছে না তোমার যা ইচ্ছে করো my lord, actually this is a matter if my lord wants to pass over, I have nothing to say, my lord. It is a bail under NDPS Act, commercial quantity. They have taken a novel ground that video recording was not done. And they are relying on a division bench judgment headed by Honorable Justice Bakshi. So if they want to argue, they can, and if they want to pass.
Yes.
My lord, whatever my lord suggesting, the matter can be fixed at 11, then.
Why? Matter is fixed here now. Yes.
And section 8C, section 21C,
See, that is all the things. Okay, and only the point is with regard to the videography was not conducted. That is the only point. And this court has filed, so call for the report from the state. The state has submitted the report due to the weather condition. What is your objection on that? Yes.
every person carries their mobile phone. My
Hmm.
lord. The mobile phone also, my lord, the camera is available.
Hmm.
They can record that in the mobile phone also. My lord.
Hmm.
My lord, and maybe it's raining weather or not, my lord.
Hmm.
Mobile phone is now essential element present with every person, my lord.
Hmm.
As we all know. So
Hmm.
the soldier present in the border also they are carrying and posting their needs, my lord. But
Yeah.
it's a very crucial situation, my lord. There are no person is carrying the mobile phone. That is one very unbelievable reason. My lord. Second, my lord, when the that has been conducted, my lord, none of the independent witness was there.
Hmm.
My lord, the fact that the conduct in the day,
Hmm.
not at night, my lord.
Hmm.
But there are many person present over there. The only reason stated no neighbors and other family members said that they will be independent witness. That is not actually the true reason. ma'am.
Yes, of course.
We can also see on the FIR itself,
Hmm.
minor, that two of the police personnel, PT Shandip Singh, page number 12, my lord, and AC Ronjit Roy.
Yes.
Both of them are the person of BSF, my lord.
Hmm.
They are the independent witness.
Hmm. They are the independent witness.
Yes. But independent figure, page number 12, my lord. Kindly come to my petition, page number 12.
Hmm.
Independent witness from the BSF person.
Where your record? Where it is?
12, my lord.
Page number 12. 12 is total. In which line you are reading? Acha. Okay.
Ranjit Roy.
Yes. Then, but as per your contention, they are not the independent witness. Okay. Correct. Then,
My lord, hardly my lord, the whole thing has been seized from one house of Jakir Goshe. And he has been also arrested, my lord. That is, you can find from page number 13, my lord. 1, 2, 3, 4, 5, 6. 6 line, my lord. Page number 36 line.
yes.
In the house of Jakir Goshe, son of Javed Ali, resident of their village, Ram Prasad. I've got that one.
Yes.
My lord, he has already been arrested.
Hmm.
At present, petitioner is custody for 356.
Where are you when the seizure was made?
My lord, according to them,
Hmm.
my lord, I was taken by the BSF person,
Hmm.
and by my disclosure,
Where you have been apprehended?
my lord, kindly come to. And nothing has been seized from my house. That also, my lord, they have stated.
That's why where you have been apprehended?
My lord, come to page number 12.
Hmm.
1, 2. My lord, 17 line. My lord, I've got that one.
Hmm.
After reach and address, I request to the villager and neighbor of the said house to become independent witness during the search and seizure, but all of them deny of becoming independent witness. After that, I request the BSF team to act as an independent witness during search and operation, which was supposed to be conducted by the police of NCB. CT Sandeep Singh and AC Ronjit Roy voluntarily agreed to become independent witness after taking the permission of their senior. The inmate in reach and moved to the said house of BSF. Both independent witness knocked the door of the person about 30 years, opened the door, being told his wife is Rahul Rahman, and he received
His wife is not, his name is.
Rahul Rahman, and he residing this house with parents, wife and one children. After that, I introduce myself, my team as officer of Narcotic Control Bureau and show my government identity card and inform him about the secret information and ask about the enter in the house which he allowed to enter. Before entering in the house, I requested Rahul Raman and both the independent witness also to sign. Personal to search of me and my team, which Rahul Raman, both the independent witness declared potential.
Okay. Yes. Then,
House.
so next, what is the ground?
Substance has been recovered from his
But he stated that he has stored the codeine in the house of the Zakir Hussain.
that is the.
That is not the-
Yes.
No. It is the contention. He has stated that then he was taken to the house of the Zakir Hussain and from the house of the Zakir. Okay. Any next?
Independent witness, no video.
Okay. Any next further? No. Yes, sir.
Lordship,
As per the affidavit submitted by you, where is the weather report?
my lord, weather report we could not collect.
Then how you can say it is the high tide and cyclone? And it is not the case made out by you during the search or at the time of filing of the
Right, my lord.
charge sheet, you are not mentioned.
Charge sheet, it is not mentioned.
So
my
whether you can made out a case in the report without the
meteorological report.
yes,
My lord, okay, we can collect the meteorological report.
now you cannot as per the after the court has been opined. Court has given a liberty to you file the report, you file the
My
report,
lord, we were,
but your mind has not gone that way.
lordship, we were only asked to clarify why we could not.
That's why.
But no meteorological report was directed to.
So that's why you
Yes,
had
my lord,
taken
we
you have taken that due to the cyclone and heavy rainy weather. What is the name? Remal. Cyclone Remal. That's why it was not conducted. It was cyclone Remal, and on that day, where is the geological survey? This report, meteorological survey report.
My lord, kindly allow me to come back tomorrow. I will file the report. I bring the report, meteorological report, because it is very easy to find out when Remal struck and when Remal went away.
And no, even though you have not mentioned, you are not mentioned in the chart sheet. You are not mentioned in the Caesar memo. Because we have seized without the videography due to the weather condition.
No, it is not in the charge sheet, my lord.
So I am releasing it. What can be
But
done?
my lord, the judgment that they are relying on, even in that case also, honorable coordinator bench went to the extent to find whether 37 was dented or not. Other circumstances made a dent in the 37 bar. But my lord, here, except absence of Remal report, nothing is on record to show that 37 mandatory bar of 37 is waived.
So if you violated the provisions of the NDPS Act while
Lord,
seizing the articles which
Absolutely,
is
my lord.
which
My
has
lord,
been declared,
I am,
which has been declared by the court as a mandatory, and you have issued
lord,
the
my lord,
notification to the effect.
kindly, my lord, takes, if the judgment is on record, my lord, they have filed.
Because they are not able to made out the such case.
No, my lord.
They have
Second
made
clause,
they have taken the exception, but there is no ground on that.
lordship, second clause says, reason for failing to videograph the recovery proceeding must be specifically recorded in the investigation record, contemporary, including scissorless inventory.
Correct.
It is not there, but court had directed us to say why we could not.
Correct.
We came up, we had only explanation that there was weather was very bad. Now, if meteorological report is required, we can file it. And my lord, if lordship takes into consideration the honorable Supreme Court's decision in Muhammad Kasif, defect in seizure and search is a matter of trial, not to be considered during the bail stage.
Census suffering from the petitioner. Census suffering from the petitioner. Census suffering from DSGI is suffering for the Union of India.
NCB.
NCB.
And one line, my lord, I would like to add if you, my lord, permit
Yes.
me. My lord, the raid was done by NCB, not BSF.
Correct. That's why, but you have taken a BSF as an independent witness.
Because none of the persons available there wanted to become a witness. That is clearly stated in the investigation report.
Okay. You will check. NCB. DSB is appearing for the NCBI. Counsel for the petition submitted that on the report of the NCB, comma, the petitioner was arrested on the allegation that commercial quantity of narcotics have been seized. The counsel for the petition submitted the petitioner was arrested on the petitioner was arrested on
Minor, 3/5/2024. 35/2024. 35.
305/2024.
30th May 2024, and since then the petitioner is in correctional home, is in custody. Police. Counsel for the petitioner submitted that the initially the narcotic control board came to the house of the petitioner and searched the house of the petitioner, but nothing was recovered from the house of the petitioner. The seizure which has relied upon by the NCB is from the house of one citizen. House of from the NCB is being recovered from the house of one Zakir Hussain and not from either from the possession of the petitioner or from the house of the petitioner. She further submitted that in the seizure list, though the NCB has shown as independent witness, but the said witness are not the independent witness, they are the witness of the BSF personnel. They are the personnel of they are the BSF personnel. They are the BSF personnel. So counsel for the police. The counsel for the petition submitted when the earlier occasion and the counsel for the petition submitted the seizure was made without the photography, without the videography, and accordingly this court has called for the report from the NCB to state the reasons as to why the videography was not conducted, as the NCB either in the complaint or in the seizure memo has not mentioned why the videography was not conducted during the seizure. During the seizure, alleged seizure. The counsel for the petition submitted as per the direction passed by this court, the NCB has submitted the report stating that at the time of seizure there was a cyclone, namely Rimal, due to which camera did not work and got wet wet, for which the videography could not be conducted. Counsel for the petitioner has filed the exception to the said report and stating that if the camera could not work, but nowadays every personals have carrying the mobile, the investigating agency ought to have conducted the videography of the LS seizure through the mobile, but neither any videography was conducted nor any reason has been assigned either in the report or in the seizure memo why the NCB has not conducted videography. The counsel for the petition submits that since the arrest, the petitioner is in custody. And what is the stage of the charge framed? No, you will not take instruction. You have not got instruction.
No, my lord, charge has not been framed because one of the accused is still at large.
Submitted since custody and investigation has been completed, but charge sheets are not supplied.
Submitted.
Charge sheet supplied.
No, charge has not been filed.
Charge sheet has been supplied.
Charge sheet supplied.
Yes, my lord.
How it has been supplied? One accused is absconded.
No, my lord, I stand corrected. My junior just, the other accused is in custody, my lord.
This case has been completed and charge sheet has been filed, but till
It is
date no
just-
charge has been framed. And thus no purpose would be served if the accused is detained in custody for further. So
Final
per
complete
contra,
charge sheet.
when a DSBI appearing for the NCB submits that.
So
Submits
they
that.
just-
That though though the NCB during the seizure has not conducted the videography and reason has not been assigned either in the report or in the seizure memo. But as per the direction passed by this court, the NCB has submitted the report wherein it categorically reveals that on that day there was a cyclone, namely Rimal, and the camera got wet, due to which videography could not be conducted. Counsel for the DSGI submit that even the videography is not conducted, that will not give right to the petitioner to get bail in the commercial get bail, though the commercial quantity of the narcotics have been seized from the possession of the petitioner. Then DSGI submits that investigation has been completed, charge sheet has been filed, and charge sheet has also been submitted to the accused persons. The trial will be started as early as possible. Heard the learned counsel for the respective parties produce the materials on record. It is found that the NCB received the information that this petitioner is having क्या बोला? Counsel for this it is found that as per the information issued by the ACB, the ACB has raided the house. NCB has raided the house of the petitioner, but nothing was found in the house of the petitioner. But the petitioner has stated to the NCB that the narcotics have been kept in the house of Zakir Hussain, and accordingly, along with this petitioner, the NCB personnel raided the house of Zakir Hussain, wherein the narcotics have been seized. It is found from the seizure list, the narcotics which has been seized is in commercial quantity, and the commercial quantity foods. But considering the above, mere that the videography has not been conducted during the seizure is a matter of trial. Other than police, as regard the independent witness, it is not a mandatory provision that every seizure is to be conducted in presence of the independent witnesses. If the independent witnesses has not been cited during the seizure, that is the matter of trial. Whether the statement of the official witness is to be relied upon or not, but that will not give right to the petitioner to come out from section 37 of the NDPS Act. In view of the above, this court did not find any merit in and did not find that the petition has come out from section 37 of the NDPS Act. Accordingly, CRM NDPS 4 of 2025 is dismissed. Yes, as per the prayer, no. What is the case? Tell me. So why you persons are appearing?
His family informed me, Lordship, that he got panic attack yesterday night. So kindly listen.
Tomorrow.
The proxy counsel appeared on behalf of the petitioner and submit that the learned advocate appearing for the petitioner is having some personal difficulties, and as such he could not able to appear before this court. Accordingly, the
Counsel for, my lord, counsel for DRI is appeared.
so appearing for the DRI. In view of the above, let the matter go and let the matter appear before the next accepted bench.
Grateful, Lord.
Great.
Yes.
Yes.
My lord, I am here for the state.
Lordship, this is my second opportunity to raise my matter. Lordship, lastly, it was rejected on 28th of November 2024.
Where is the order?
Lordship, at page 11.
Page 11.
Lordship. My argument solely based on.
Photograph was not taken. Both inventory of the system were prior to the submission of the charge sheet. Prior to the FSL report were prior to the submission of the charge sheet. Charge sheet was submitted with the chemical examination report, quantity brown sugar. Yes, then
Lordship, I will take you, Lordship, to the page number 20.
what is the new ground is brought here?
Lordship, 2 points.
Yes.
Number 1, it's at page 20, the report.
20.
20.
Yes.
The date of receipt of the sample was 12th April 2024. Lordship,
Where is page 20?
after
There is
charge sheet.
There is no page 20 here.
Page 20 of your application.
Yes.
Koনটা?
Where
Mark-
it is?
mark it করুন না।
11,
Report, Lordship.
12.
Page 66, is it 66 of what?
Just a certified copy. Before that, after charge sheet.
After charge sheet.
Lordship.
Yes.
Yes. You have not paginated it here.
Yes, certificate of the test analysis,
Lordship,
narcotics,
because they
psychotics.
received on 12th of April 2024.
Correct.
Whereas the report was prepared on 13th of September 2024.
13th of,
September 2024.
where you got?
Lordship, below. With the signature, sir.
13th September. Correct.
There is a huge delay in this.
Hmm.
The coordinate bench of this honorable court has already decided.
Just a minute. 12th April, when is the seizure was made? When the seizure was made, sir?
Lordship,
Caesar? No.
6th of April 2024.
6th April 2024.
Yes.
When the certificate of correctness of inventory was taken,
Lordship, that I don't have that copy.
you not have a charge sheet.
No. Charge sheet I have,
Ah,
Lordship.
in the charge sheet, it has not been supplied to you.
Well, I am.
Now, if your Lordship may kindly come to second paragraph of charge sheet at page 19, just before the FSL report.
Page,
Page 19, 19.
there is no pagination.
I have the pagination.
I don't know, the office might have been deleted the pagination.
No, maybe there may be some mistake from my part also, Lordship, but
You have filed the certified copy, how it can be pagination? This is a certified copy, how it can be paginated? What you are telling, sir? Yes, the report which you are relying upon.
yes.
Correct.
Number-
12th
number-
April is the receipt and September 24 is
Inventorization was done on 7th one.
12th September, 13th September is the report.
Lordship,
Yeah, this is your first contention.
first contention.
Then,
Lordship, coordinate bench of this honorable high court has already decided in this matter. The delay in FSL, filing in FSL, CRM 384 2024, I'd like to hand over the order. Lordship, may kindly see page, paragraph, second page, para 2. It's a custody for about 370 days. So,
para 2,
para 2.
London Council submit that 370 days. Apart from the charges, include the packet of Winsompo so we did not find place in the seizure list itself, thereby casting doubt upon the seizure investigation. Then,
I like to take you to paragraph number 4 also. However, in as narrated above, we find a gross violation of Rule 14 of the NDPS Rule 2022.
for 15 days.
Lordship, that is
Correct.
the point, number 1. Second, the Ravi Prakash judgment, which Lordship also followed in some of the matters in last week. Lordship, I am about 410 days is in custody. Charge sheet has already filed on 28th of September 2024, which is at page 18. 207 has already been complied with. I am in custody about 4011 days. Today is
4011, 4000,
411.
411 days.
411 days.
Ah.
It's about 1 year, 1 month and 15 days.
Correct.
Lordship, these are the two.
What is the stage of the trial?
Lordship, nothing.
Well,
Just
copy has
how many
already been
witnesses?
served.
How many witnesses? I will come to you.
15.
15 witnesses. None of the witnesses have been examined.
Lordship, charge has not yet been filed.
So,
Lordship, even the last order, my last contention, if your Lordship may come to page, second page of the last order.
what has been seized from you, your possession?
Lordship, it's a.
469 grams.
What?
Lordship.
469 gram what? Ganja?
No.
Had it been so,
You
my
are
lord,
not
would have
telling what
granted
has
the
been
bill by
seized
now.
from you. Brown sugar.
Lordship, last order, it was, we request to conclude the trial expediently. So it was in the November, not till date. Charge has already been framed, everything, the prosecution, all the witness and all this thing has already been fixed.
30th January charge was not framed.
No, Lordship,
What has happened on 30th January?
Lordship, I am telling. Lordship, 13th January 2025 was the 19th of.
Thereafter 27th February. What has happened 27th February?
Date will given on 28th of March. 28th of March, date was given to 2nd of May,
So what has happened? Only adjournment.
only adjournment.
Why?
The original CD was lying here.
Huh?
Lordship, how
Original
can it
CD
be?
was lying here. When did you file it? In the earlier occasion also the CD was here, my lord.
So you
Have
persons
we
are
seen
filing an
at last
application.
Lordship,
When you filed that application?
26/3, my lord. So CD was called for on
26/3.
28, it could not
Huh?
be framed.
Lordship, it is not actually, because the matter earlier when listed on 2nd of April, it was went back and then the record was again called for when I have mentioned.
By
this
which
matter.
order the record was called for? There is no record is called for, sir.
Last Friday.
Not the record, my lord, but the CD. For framing
Court
of
has
the-
not called for.
No,
Then
the CD.
court has not called for the CD.
What
You,
is it?
you himself has keep the CD with you, knowing that the petitioner is in custody.
No, my
Court
lord.
has not asked you to bring the CD here.
My lord, they filed it 26/3/2025,
Maybe.
my lord. On
Maybe,
28th was the next date, my lord.
maybe.
Naturally, CD came on 27th, my lord.
This matter was filed on when?
26th, my lord. The
26th
copy was
of?
served upon the PP office.
26th of March.
26th of March and
Then-
28th of March was the date,
26th
my
of
lord.
March, the CD was, when you have take the, receive the CD.
That I don't have that endorsement here, my lord. I have to check with the office.
So why the 31st January, then 27th February? Then when the March, what was the March date? What was the March date?
It was 28th of March, my lord. 28th. 26th he filed, my CD was here. Naturally.
12th of March, then 2nd of May,
Then
and in between the
The next
matter
day
was
we'll
out
fix.
of this
We'll
lordship.
frame the charge.
what fix?
Frame
When
the
is the
charge.
next date?
That's right.
You person should not do like this.
3rd of July.
If the accused in custody, the case is fixed for framing charge, you are bringing the certified copy, why you are not taking the original copy unless and until the court is called for?
My lord, may I submit, my
Yes.
lord? We used to call for the certified copies only.
Still all
For the high courts, it is happening, my lord. It was the practice here, my lord.
Ah.
But there was a specific instruction by Justice Bagchi once, my lord. That's thereafter we have started calling the originals.
Where is original? I didn't find any original in my circuit. I didn't find any original. Now you are telling that the original, only I called one original, two original. Yesterday one matter, and now PP. Nobody is producing the original, sir.
আমাদের তো instruction ছিল না একটা original.
Why you are making the false submission before the court?
No, my lord, I didn't.
For the last 10 days, I am here. I am dealing with the bail matter. None of the original CD has been produced, and I have put that question. And it was on that day, it was informed to this court. This court has directed to produce the certified copy. That's why you are producing the certificate. Now you are making the submission otherwise.
No, we don't call. We intend.
And if the case is fixed for the charge, why you have called for the CD? Why you are not informed the court? You accused in the custody. All wrong things are you doing. You are calling the victim girl in the court. You are bringing the original CD with you. If the case is fixed, charge or fixed for evidence. What instruction you are giving to the PPs appearing in the lower court?
My lord, actually, there was an order, my lord, key to.
But I know that that
But
discussion was
sometime,
held.
my lord,
That discussion was held because
within
2-3
2 days-
matters, 2-3 matters, we find something was happened.
My lord, today there is a matters item number 10. I'm holding the original CD, my lord, because we always ask for the original CD as
No,
per the.
please, you ask the original, first you see if the
My
witness.
lord, right, that's the thing we should have said
If
back.
the case for fixed for tomorrow, the case
My
is
lord,
fixed for charge.
that-
Why you
that-
are bringing? You can tell the court,
That's
yes,
true,
today is
my
fixed for charge, I will produce tomorrow. The
That's
court
true.
will not,
We
kill
should
you.
have- What happens, my lord, we should have written it.
Because I find on last occasion, the victim girl,
No,
you have taken the stand that because victim girl could not be examined because the CD is before the High Court.
I didn't bring the victim.
No, some other matters, I am not telling you. That is the appraisal. Why you are not January, February, March, you are not, why you are not framed the charge?
Friend the charge.
Why? Why? Tell you, give the explanation. Why you are not framed the charge? What your PP was doing? What your PP was doing in the lower court? Very easily you are submitting before this court, then you will frame the charge. Playing with the person who is in custody. And you are also not pressing before framing of charge, you filing an application and taking time and time.
Lordship, if it is so, Lordship may kindly consider this order. This is the coordinate bench order, Lordship. The CD was returned back, and after my mentioning the matter was listed in this particular week, and now the CD has come. Not only this, I also want to
And
take.
nothing in the order sheet of the learned judge that the PPS stated that CD is not available.
Produce the accused even in court.
In the order sheet of the trial court, there is nothing in that the PPS asked for the time because the CD is not there. If this matter will go to the Supreme Court, what will happen? The High Court will be blamed. Keeping the CD with the High Court and accused is remanded to judicial custody. What it says?
It said the matter has not been listed, and so CD has
No.
already been went back.
None affairs go out of the list.
Lordship, and the matter.
How the court interpret this order?
Lordship, I have taken my chance. This is the thing which I can present before your Lordship. And beside this, Lordship, I want to present another judgment of the coordinate bench. Lordship may kindly consider paragraph number 2 and paragraph number 4. I am also requesting to consider the Ravi Prakash judgment also. Lordship has already considered in so many cases.
কিছু কাজ করে না নিচের কোর্টে।
Brown sugar, what is the quantity?
450.
Minimum quantity?
250 is the commercial quantity, my lord. 469 grams. 250 grams is the commercial quantity.
Where it is? By which clause?
By in the schedule, maybe.
Which clause? So that's why I'm asking which clause.
দেখতে পারবি না দাদা আমাকে দেখে দিন। Lost তো খুঁজে পাই না আমারও চারটা কই এই কোথায় চলে গেছে হেরোইন
Heroin.
কেন নতুন বই না এটি প্রবলেম হবে
এটা নতুন ইনক্লুশনটা
আসছে নাকি ব্রাউন সুগার বলে তো দেখা নেই
হেরোইন বলে হেরোইন Yeah, I'm sure.
My lord, it's 56, my lord, serial number.
Huh? What?
56 of the chart, my lord, serial number 56.
Correct, heroin, 250.
Yes, sir.
250 is the commercial. And 469 has been required from you. 5 gram is the small.
Scientific name is diacetyl morphine, my lord.
Yes, which judgment, what judgment you are relying upon?
Lordship, CRN, NDPS 3C2 of 24, Lordship.
Correct.
Lordship, paragraph number 2, as
Hmm.
well as paragraph number 4.
What the two says?
Lordship 2, Learned counsel further argued that the sample were received by the laboratory on November 24, 2023, whereas the chemical analysis report was given by it on April 30, 2024, after the delay of about 5 months.
Hmm.
In my case, it's also supposed it's about 4 months.
Hmm.
And Lordship, in 4 paragraph, again the Ravi Prakash
Hmm.
for the long detention. Here is the 260 days. 260 days. Mine case, it is 411 days, Lordship. So these are the only 2 points I'm pressing before your Lordship to kindly consider. Moreover, charge has already been, charge sheet has already been deposited by the prosecution. So there is nothing more to investigate. If your Lordship may kindly consider this.
Yes. Yes, what is the contention, sir?
There is seizure of commercial quantity, my lord,
Hmm.
and rule for
When the
40.
charge sheet was filed? When charge sheet was filed?
28th of September
28th of
2024.
September, my lord.
2024. When the charge sheet was supplied? When the charge sheet was supplied?
Thirtieth September 2024.
Order sheet level. Order sheet is another one. Order.
September 2024.
Lordship,
And you are in custody.
Lordship,
And every day you have been produced.
Lordship,
29 September.
30th September.
30th September, charge sheet
28th
supplied.
September charge has been
Yes,
charge
sir.
sheet given. Order number 15, 30th September 2024.
Supplied.
Lordship.
Yeah, you received charge sheet through special PP. 30th 9/2024.
In this case, one more thing, Lordship, the report
Hmm.
has been given to the police officer. Then through PP, it was filed in court.
What?
Lordship, the report, FSL report was going to the police officer. And then police officer through PP filed the same in court. It's same is in 30th September 2024. The report was not directly given to the court.
Wherefore you got?
Lordship, this is 30th September 2024 order, as well as the FSL report where it is said only to the OC.
Not sent to the magistrate.
No, Lordship.
No, kindly see. Police station, Matigara police through the additional chief regional manager, proceedings and so. To him it was sent.
To the police officer.
Where you find? Where you find? Where is the?
Lordship, page number 21. That is after the charge sheet.
Correct.
And also reflected in the order of the trial court. On 30th September 2024 order. Order number 15.
30th September.
Lordship.
And on the same day, the copy was supplied to you.
Lordship. First paragraph, last 2 lines. Along with one original chemical examination report bearing report number such and such.
Yes. Yes, sir.
My lord.
But delay that to that is directly to the court, directly to the IO, not to the court.
No, this is the practice in Shiliguri, my lord.
Huh?
It is always in Shiliguri,
It
this is
cannot
the
be.
practice. It
It
is
cannot be, Lordship.
It is the practice in Siliguri. যে PP receive করে PP submit করে। এই order sheet টা দেখুন।
If you receive the inventory from the court, the report is to be submitted to the court.
Yes, ma'am.
Then
Yes.
suffering for the petitioner, suffering for
Order sheet টা দেখুন।
the state. The petitioner has filed the present application. Petitioner has filed the present application praying for bail in connection with Matigara Police Station. Matigara Police Station case number 235/2024 dated 6th April 2024. Under section 21 within bracket C of the NDPS Act 1985. Now pending before the learned NDPS, learned special judge within bracket NDPS second court Siliguri. Police. Counsel for the petition submit that the petitioner was, the police of PS Matigara had initiated the above case on the basis of the seizure list. Since after the arrest, the petitioner is in custody. As per the case made out by the police, alleged 459 gram.
Yes,
469.
469 gram.
469 gram of brown sugar is alleged to have been seized from the possession of the accused. Counsel for the petition submitted that the report was submitted and the narcotics and the alleged narcotics was sent to the CFSL, to the State Drug Control and Research Laboratory on when it was sent.
12th April 2024.
6th April,
12th.
where is find?
Back to that page 20.
On 12th April 2024. And as per rule 14, the State Drug Control and Research Laboratory has to submit the report within 15 days from the date of receipt of the receipt of the materials. But in the present case, the State Drugs Control and Research Laboratory has submitted the report only on 13th of September 2024. That is about 5 months from the date of receipt of the materials. Police counsel for the petition submit that this is the pure violation of rule 14 of the NDPS rules 2022. Counsel for the petition further submit that the after the investigation, the police has submitted charge sheet, and the charge sheet has been supplied to the petitioner on 30th September 2024. Thereafter, several dates have been passed, but till date, no charge has been framed. Counsel for the petitioner further submit that the State Drugs Control and Research Laboratory ought to have submitted the report to the learned court, but instead of submitting the report to the learned court, it was sent to the officer in charge of Matigara Police Station. This is also the violation of the NDPS rules. Counsel for the petition submit that the petitioner is in custody for the last 411 days, and till date charge has not been framed. He further submitted as per the charge sheet altogether 15 witnesses have been cited, which will take further delay, and the accused is to be remain in the custody. Per contra, learned advocate appearing for the state submits that the commercial quantity of the narcotics within bracket brown sugar has been seized from the possession of the petitioner, Full stop. As per the FSL report, it is found that the material seized from the possession of the petitioner is the narcotics coming under the commercial quantity. Full stop. He further submit that the investigation has been completed. Prosecution has submitted and charge sheet has already been supplied, and immediately the charge will be framed and the witness will be examined. He further submit that the petitioner has not made out any case so that he come out from section 37 of the NDPS Act. Had the learned counsel for the respective parties peruse the materials on record. This court finds that the petitioner was arrested on, what is the date of arrest? Arrested on
6th of
on
April
6th of
24.
April 2024. And since then, the petitioner is in custody. The police has submitted charge sheet on 30th September 2024. Counsel for the petitioner has drawn the attention of this court to the daily order sheets of the London trial court, which finds that every month the case was fixed before the trial court, but the prosecution failed to frame the charge against the petitioner. This court also find that the state drugs control the State Drugs Control and Research Laboratory received the materials for examination on 12th April 2024, but the report was submitted on 13th of April 2024, that is after the period of 5 months, 13 September 2024, where that is after the period of 5 months, wherein Rule 14 of the NDPS Rule 2022 provides that the report has to be reached within 15 days from the date of receipt of the materials. Though in our country there is dearth of CFSL examination, CFSL laboratory, but this court find that the delay in filing the report for 5 months is much delay which cannot be condoned, which can be taken, which can क्या बोला? Though in our country laboratory for which the court is getting and the investigating of agency is getting the report delayed, but in the present case the investigating agency has received the report after the 5 months, which cannot be appreciated. Secondly, the CFSL authority, instead of sending the report directly to the court, knowing that they are sending the report after the period of 5 months, have sent the report to the IC, to the in charge of the concerned PS instant to the court. Full stop. When the court has inquired from the prosecution why the prosecution failed to frame the charge, though the charge sheet has been framed the charge till date, though the charge sheet has been supplied on 30th September 2024, the learned counsel for the state submits that the CD was with him due to the bail application filed by the petitioner. Full stop. This court find that initially bail application was filed. Where is the earlier order?
Page 11, 28th November 2024.
Filed 28th of October, November 2024. On that day also, the charge sheet was on record but no charge was framed. But this court has rejected the prayer for bail on the submission made by the prosecution that the trial will be started soon.
28/3/2025 on the date when.
So why is September to, okay, I am taking that. Why September to March charge has not been framed? क्या बोला?
The bill application was filed.
ना क्या ऊपर क्या बोला?
This court find.
हाँ.
When the court has inquired
on
the prosecution, why the prosecution failed to frame the charge.
Charge.
Yet, though the
charge
charge sheet
that.
has been supplied.
No, full stop, particular, comma, file, comma, the learned counsel appearing for the state submit that he cannot give any reply with regard to framing of a charge from the month of September till the month of February 2024. He submits that he got the original CD on
29th, it was forwarded on 28th.
28th of March.
29th of March, our office got it. Here is the endorsement.
When you received on 29th of March 2024, 2025, due to which for this period the charge could not be framed. But the learned advocate appearing for the state failed to justify why the charge has not been framed from the month of September 2024 till the month of March 2025, when the CD was sent to the learned advocate appearing for the state for hearing of the present bail application. Full stop. Considering the above, this court find that though the commercial quantity of narcotics has been as alleged to have been seized from the possession of the petitioner, but this court find that the CFSL authority has sent the report after the period of 5 months, comma. The police, even after supply of the charge sheet, comma, the London trial court failed to frame the charge for the last September, October, November, December, January, February, March, April, May, for the last 9 months. 9 months. And the CFSL authorities have sent the CFSL report directly to the in charge police station instead of sending to the court. Considering the all aspect, this court inclined to bail to the petitioner for furnishing bond of rupees 20,000 with 2 sureties of like amount, if out of which 1 surety must be local. 1 surety must be local with the satisfaction of the Leonard Court of Leonard Special Court NDPS Siliguri. So if on bail, he shall appear before the trial court on each and every date of hearing, and he shall not hamper and tamper with the evidence. Full stop. Supera. This court finds that after filing of the bail application, comma, the learned PP or the advocates appearing for the states are bringing the original CD from the learned PPs or APPs appearing before the trial court, due to which the trial is being hampered. Either the charge could not be framed or the witness could not be examined due to non-availability of the CD before the PP who is conducting the trial before the trial court. In view of the matter, I direct to all the PPs and the state advocates who are appearing on behalf of the state, before call for the CD from the learned APP who is conducting the trial in the trial court, take instruction what is the stage of the trial. If when the CD is called for or is required, and on that day, if the case is fixed for charge or evidence of the witnesses, only the certified copy of the CD will produce before this court, and to inform this court for production of the certified copy and why not producing the original copy. It is made clear that only because the CD is called for by this court at the time of hearing of the bail application, comma, the trial should not be hampered. This order may be circulated, and the registrar is directed to circulate this order to all the PPs and state advocates appearing before this court, and all the PPs and APPs who are appearing before the trial court for their information.
Right, order on the city was it is not there.
What, I cannot clarify. What you stated that I recorded. That's why I stated. For that, you are not given any explanation. Why the trial court has not not framed the charge. Yes.
Obliged. I remember my.
Why?
Council is indulged with the matter in September.
So,
I remember 10.
The petition. Lord has heard this matter substantially, Lord, on the last petition.
yes,
And today's fixed from Lord, a reply from the state.
yes.
Lord, I have prepared a brief note of arguments along with the compilation of judgment, Lord, though it has already been given, Lord, but a compilation has been prepared.
Give us a copy.
कंपाइलेशन पहले था क्या हुआ? पहले कंपाइलेशन दिया हुआ था कहाँ है?
But previously it was not compilation, single judgments, Lord, I have given. So
Okay.
now.
Yes.
Luck. Lord, before I start, my lord. Also, though they have given the written notes today, I have also prepared a written notes. After my submission, I'll be filing that. First of all, the facts of the case, my lord. What is the fact of this case? That this petitioner was apprehended with 40 bottles of RC cough syrup, 100 ml each. And in presence of the WBCS officer, one gazetted officer, who is a magistrate, my lord, in his presence, the search and seizure was done.
Whose presence?
The BDO Alipurduar block, who is
Executive magistrate.
my lord, executive magistrate.
Yes.
And notice under section 50 was served to him.
To the
Thereafter,
accused.
videography was done. And in section notice, the entire things are written. What is the case? What we suspect? Before whom we want to be searched? And there is the signature of the petitioner also. Thereafter, personal search memo was done, where he has signed. Memo of arrest was done. Seizure list was done, where he has signed. And ultimately, he was forwarded before the learned magistrate. There was a forwarding report where entire thing was disclosed. And there was a remand prayer of 3 days also. Now, regarding the statutory framework governing arrest and communications of ground, my lord, the prosecution relies on the following constitutional and statutory provisions to demonstrate the arrest procedures were lawful and that the accused was duly informed about the grounds of arrest. So where it is Article 22(1) of the Constitution of India.
Correct.
What it states? Guaranteed that no person arrested shall be detained in custody without being informed as soon as possible. This is very, very vital. This word as soon as possible. The word immediately has not been used.
As soon as possible.
The intention of the legislature is very clear. Why not immediately, as soon as possible, of the grounds of his arrest? And additionally, the arrest shall not be denied and the result consult and defend by a legal practitioner of their choice. So that was the motto, my lord, that he should be defended by someone. Moreover, the use of the term inform as per Article 22(1) of the Constitution, my lord, indicates that the communication of the grounds, must be effective and meaningful, but it does not mandate that such communication has to be in writing. Now they have placed Pankaj Bansal. I will be relying on some of the paragraphs observation in the matter of Pankaj Bansal. Now what section 52(1) of the NDPS says, my lord? Mandates that any officer arresting a person under section 41, 42, 43, 44 of the NDPS Act, as soon as same word has been used, as soon as may be, inform the arrested person of the grounds of such arrest. The phrase as soon as may be implies a reasonable time frame, which has been judicially interpreted to mean that practically period of typically is 24 hours. Within 24 hours, they have to be produced, my lord. So that is, they have to be informed. So here, the word as soon as possible means within 24 hours, he has to be informed. Next, they have cited some citations on the basis of the PMLA, my lord. And I'll come to section 19(1) of the PMLA. Section 19(1) of the Prevention of Money Laundering Act, my lord, similarly requires that the arresting officer inform the arrested person of the ground as soon as possible. So here in the Constitution, NDPS Act, as well as the PMLA Act, the word as soon as possible is there. This provision has been extensively interpreted by courts to clarify the scope of communication, including the permissibility of oral communication. At the time of frame of compliance, the analogy is relevant as both as NDPS as well as the PMLA Act, as special statutes dealing with serious offences, and their arrest provisions share similar language and intent. Next, my lord, section 35, conscious position. Presumes a culpable mental state, including intention, motive, or knowledge. Here we have to see on the facts of the case whether he has the knowledge of carrying some illegal goods or not. He was carrying 40 bottles. He knew that without the papers, these are all illegal. So it was within his knowledge what he is carrying, what offense is already he is going to do if he is apprehended. Motive of offense, placing the burden on the accused to prove the absence of such mental state beyond a reasonable doubt. This provision is critical in establishing conscious possession, which requiring both physical control and mental awareness of the illicit nature of the narcotic drugs. Section, my lord, I will be coming to section 37 also, as I have made a written notes, that imposes stringent conditions, my lord, for granting bail in cases involving commercial quantities of narcotic drugs, and second, the court must be satisfied there are reasonable grounds to believe that the accused is not guilty of the offense first. That is the main thing. Second, the accused is not likely to commit any offense while on bail. And another is this condition reflects the legislature intended to curb drug-related crimes by limiting judicial discretion in granting bail. So these are section 37. Now, judicial interpretation of the main ground which they have raised is regarding the ground of arrest and compliance. The prosecution relies on the robust body of the judicial precedent to establish that the ground of arrest were effectively communicated to the accused, and that oral communication supplemented by the remand application fully complies with the legal requirements. Now, I'll be citing one decision. This is Neeraj Singhal, State Director of Enforcement. This is an bail application. That in paragraph 13, I'll be giving all the citations, Manoj. I'll try to give a copy if those are unreported. In Ramkishore Arora, paragraph 13, the Supreme Court also noted that expression as soon as may be, as occurring in section 19 of the PMLA, has not been specifically explained in Vijay Mandal Chaudhary versus Union of India, or the said expression has been interpreted in either V. Senthil Balaji or in Pankaj Bansal, which they have cited. Accordingly, the court observed that the interpretation of expression as soon as may be assumes significance, referring to the judgment of the Constitution bench in case of Abdul Jabbar, but and another State of Jammu and Kashmir, and a 3 judges bench decision in Durgapada Ghosh versus State of West Bengal, our own High Court, my lord. The court held that the expression as soon as may be contained in section 19 of the PMLA is required to be constituted as early as possible without avoidable delay or within reasonable convenient or reasonable requisite period of time. The court also observed that the reasonable convenient or reasonable requisite time to time inform the arrestee about the ground of his arrest would be 24 hours arrest. Paragraph 39 of the said, my lord, states that before proceeding further, it would be referred to law laid down by the court in Moin Akhtar Qureshi, wherein it was observed under paragraph 65. I mentioned all the paragraphs, my lord. On consideration of the aforesaid decision relied by the learned counsel, the positional law which emerges is as follows. The procedural safeguard in clause 1 of article 22 of the Constitution are meant to afford the earliest opportunity to the accused persons to remove any mistake, misapprehension, or misunderstanding in the mind of the arresting office authority, and also to know exactly what the accusation against him is, so that he can exercise the second right, namely a consulting a legal practitioner of his choice and to defend him. Clause 2 of Article 22 provides the material safeguard that the arrested person must be produced before a magistrate within 24 hours of such arrest, so as the independent authority exercising jurisdictional power without delay apply its mind in his case. Now here we honor the Article 21. Once a person is arrested, the right under Article goes out. He doesn't have the right under Article 21. Now here, my lord, neither section 19(1) of the PML Act, what my learned friend has stated, nor the definition expression order as given in subclass H of Rule 2 of the PMLA, arrest rules provide that the ground of such arrest are mandatory required. Be provided in writing to the person arrested at the time of arrest. Oral communication of the grounds of arrest is not only a substantial but proper compliance of the provision. Section 19(1) also does not state that the grounds of arrest are to be informed to the person arrested immediately. The use of the word in section 19(1) as soon as may be makes it clear that the ground of arrest may not be supplied at the time of arrest, which they are, my lord, hitting on that point constantly, that it has to be mentioned at the time of arrest. It has to be in the memo of arrest. No.
That is the contention.
My
That is
lord.
the contention of the petition
My lord.
with regard to the grounds of
Now,
arrest is to be mentioned.
now
in
it
the
is
arrest.
written, my lord, here. The use of the word section, ground may not be supplied, but as soon as may be, this is also Chhagan Chandrakanto Bhujpal case also, it has been same thing has been described. Now, Your Honor, another paragraph 73 of the said judgment, my lord. Pertinently, section 19 of the PML Act also used the word expression informed of the ground of such arrest as used in Article 22 and does not use the expression communicate. So there is a difference between informing or communicating. The words are different. It has to be interpreted in such a way. Information and communication. Communication in writing. Information, it can be oral. It's not that it has to be in writing. It's not a mandatory provision, which is also used in Article 22. Since the section 19 deals with the power of arrest, the scheme of section 90 engraves an additional safeguard against the misuse of the power arrested by the competent authority by stipulating in subsection 2 thereof that the competent authority shall immediately after arrest of such person under section 1 forward a copy of order of the arrest along with the materials in his possession, on the basis of which reasonable belief is formed that the person is guilty of an offence punishable under the Act, in a sealed envelope to the adjudicating authority, which the adjudicating authority is obliged to keep under his safe custody. So already a copy is sent to the court, a copy is sent to the authority, my lord. We may also observe that the obligation cast on this competent authority under section 19(1) is to inform the arrestee as soon as may be of the grounds of such arrest. Section 19 does not oblige the competent authority to inform, serve the order of arrest or the ground of such arrest to the arrestee. Simultaneously with this arrest, in the present case, the petitioner was informed of his ground of arrest at the time of arrest itself. Now, you know, another very important point is that in the fact of the present case, the petitioner in any event came to inform the reasons of his arrest when a detailed application was moved before the learned special judge on 26/8/2020, that is their case, the day following his arrest, setting out the materials which also virtually contains the grounds of arrest. The said application was admittedly served upon the petitioner on, this is that case, my lord. This is the last paragraph, my lord, paragraph 76. Thus, the petitioner in the event of arrest, thus the petitioner in any event became aware of the grounds of his arrest when he and his legal practitioners were provided with a copy of the application under section 167, my lord, read with section 63 of the PML Act, the citation which they have given dated 26/8/2017. Now, what Moin Akhtar Qureshi says. Clearly, Moin Akhtar Qureshi lays down that oral communication of the ground of arrest is not only a substantial but a proper compliance of the provision. Section 19A of the PML Act does not oblige the competent authority to inform, serve the order of arrest or the ground of such arrest to the arrestee simultaneously with his arrest, but as soon as may be, and when the arrestee or his counsel is provided with a copy of the application filed by the ED, this is the case of the ED, my lord. Section 160, read with section 65 PL Act, section seeking custody demand, he will stand inform the terms of 19 of the PMLA if the said application set out the materials which also virtually contain the grounds of arrest. Now, the issue deserves to be considered from yet another angle is that in that case, my lord, the respondent ED has moved an application under section 167 CRPC seeking remand. Here also remand was taken for 3 days under section 167. Upon the learned counsel for the petitioner before the learned special judge, the remand application was juxtaposed with the grounds of arrest, reveals that the remand application virtually contains the ground of arrest. Therefore, in view of the law laid down in Moin Akhtar Qureshi, The petitioner stood informed of the grounds of arrest in terms of section 19(1) of the PMLA. When he was produced before the learned special judge within 24 hours from his date of arrest, ED was seeking the bail. Insofar as the petitioner contends that the concerned officer did not forward a copy of the arrest order along with the materials in his possession immediately to the authority, adjudicating authority in terms of the mandate of subsection 2 of the section 19 of the PMLA is concerned, same also devoid of merit. The petitioner was arrested on Umuk, which happened to be a Friday night. That was Friday, Saturday and Sunday, the court was closed. Mr. Hessen, that on Saturday, Sunday, the remained closed. Therefore, copy of arrest, here the General Clause Act comes, my lord. The copy of arrest order along with the relevant materials was immediately forwarded on Athu. It is street law that where a period is prescribed for the performance of the act of court of the office and that period expired on a holiday, then according to section 10 of the General Clause Act, 1897, the act should be considered to have been done within the period if it is done on the next day on which the court office is open. So that is a clear, it's a central principle of law. So now, Your Honor, from the whatever citations regarding the PML Act, I have said the PML NDPS Act and the constitutions, the words which have been used are same. Now the court has also, thus from the above, it is have interpreted that the phrase as soon as may be under section 19 MLS meaning as early as possible without avoidable delay or within a reasonable convenient requisite period, typically within 24 hours of the arrest. The interpretation applies equally to section 52(1) of the NDPS Act, my lord. It applies also to the NDPS Act also. The court has also oral communication of the grounds of constitutional substantial and proper compliance with the statutory requirement. Section 19 of the PMLA and any analogy section 52(1) of the NDPS Act does not mandate that the grounds be provided in writing or simultaneous with the arrest. The obligation to inform the accused as soon as may be along for a reasonable time frame post-arrest. The court further clarified that when the accused or their counsel is provided with a copy of remand application under section 167 CRPC which contains the material constitute the ground of arrest, the accused is deemed to have been informed with terms of statute. In the contest case, the court noted that the remand application by the enforcement department, they are directed within 24 hours of the arrest, virtually contain the grounds of arrest, thereby satisfying the requirement of informing the accused. Now a question lies whether ground of arrest has to be informed in writing as enumerated in the order delivered by the Honorable Justice of Supreme Court in Pankaj Bansal versus Union of India, reported in which they have cited, reported in 2024, volume 7, Supreme Court cases, page 570C, decided on 3rd of October 2023. Now there are conflicted judgments after this manner of various high court as to whether oral communication is sufficient or whether some high courts have specially stated that the grounds of arrest should be writing. It's not that all the high courts have taken the same view. I'll be citing those judgments of other high courts after the passing of Pankaj Bansal case, my lord. In order to support my contention, my lord, I have relied upon a judgment and observation of the Supreme Court delivered after the order given in Pankaj Bansal versus Union of India, which is decided in 3rd of 10th. So this judgment is in Bihan Kumar versus State of Haryana.
Yes.
And others decided on 7th of February 2025. The Honorable Supreme Court was an observation of the Honorable Supreme Court. Therefore, as per Article 22 is concerned, compliance can be made by communicating sufficient knowledge of the basis fact constituting the grounds of arrest to a person arrested. The ground should be effectively and fully communicated to the arrestee in the manner in which he will willfully understand the same. Therefore, it follows that the grounds of arrest must be informed in the language which the arrestee understand, which is conversant, my lord. That is how, in the case of Pankaj Bansal, this court held the mode of convening the grounds of arrest must necessarily be meaningful so as to serve the intent purpose. However, Article 22, there is no requirement of communicating the ground of arrest in writing. Article 22(1) also incorporates the right of every person arrested to consult an advocate of his choice and the right to be defended by an advocate. If the grounds of arrest are not communicated to the arrestee, as soon as maybe he will not be able to effectively exercise the right to consult an advocate. This requirement incorporated in Article 22 also ensures that the ground of arresting the person without a warrant exists. Once a person is arrested, his right to liberty under Article 21 is curtailed. When such an important fundamental right is curtailed, it is necessary that the person concerned must understand on what ground he has been arrested. That is why the mode of conveying information of the ground must be meaningful so as to serve the object stated above. Paragraph 15, my love, we have already referred to what is held in paragraph 42 and 43 of the decision of the case of Pankaj Bansal, which my learned friend has cited. This court has, there are some observation. This court has suggested that the proper and ideal course of communication of the ground of arrest date is to be provided grounds of arrest in writing. Obviously, before a police officer communicates the ground of arrest have to be formulated. That is the observation of. But here, my lord, therefore, there is no harm. If the grounds, they have stated, their observation is there, paragraph 42 and 43. Therefore, there is no harm if the grounds of arrest are communicated in writing. Although there is no requirement to communicate the grounds of arrest in writing. There is no harm if it is done, but it is not necessary. In writing, what is stated in paragraph 42 and 43 of the decision in the case of Pankaj Basras are suggestions that merit consideration. These are only suggestions. This is nothing else. This is only for suggestion. We are aware that in every case, it may not be practicable to implement what is suggested. If a court gives a suggestion, in all cases, it's not that it can be applicable, my lord. If a course as suggested is follows, if the course as suggested is followed, the controversy about the non-compliance will arise.
See, all, if you go with all the orders,
my lord.
even the Vivan and the.
My lord, I'm coming, my lord.
No.
Latest position of Supreme Court.
That's what I'm telling. So even the Supreme Court and the other high courts, it is the duty of the prosecution to prove whether it was informed to the accused or not. That is the only crux,
my lord,
which prosecution has to justify. Yes, this is the document which proves that communication.
My lord.
That's all.
My lord, now after that, my lord,
because it is not denied, it is not to be communicated. It is admittedly under Article 22(1) has to be. And why it has to be communicated? Because the accused can get the legal aid and all that. That is the only thing. So you have to prove from your document, because every case depends upon its.
Now I'll come to the facts of the case, my lord. In Keith's case, whatever in the instant case, my lord, it's pertinent to mention that we look closely into the ingredients of it is specially written by the investigation officer, my lord. If my lord goes to the complaint, it's written by the complaint. It's wrong. This will be the complainant.
Yes.
That the grounds of arrested were communicated, be it any mood and effective oral communication. It is in the FIR that the grounds of why he was arrested, it is there. I'm holding the CD, my lord. I may be excused for, I've just made some pencil marks, maybe I've excused, I may be excused for that, my lord. This is the FIR. Now here it is mentioned why he was arrested. The grounds are mentioned. Be it an effective oral communication is also sufficient to justify the accused was informed of the grounds of arrest. Apart from this, that the accused person is in conscious possession. My lord, section 35 of the NDPS Act, conscious possession of 40 bottles of syrup, which means that it is well within his knowledge that he was carrying something illegal in the eyes of law. Even he was further informed when an application for remand under section 161(6) CRPC was preferred before the learned magistrate, well within the prescribed time frame. From the above three instance, it is hereby that the prosecutor has deliberately informed and communicated the grounds of arrest to the accused person. Now I come to the latest judgment of the Supreme Court, which was in relation to a judgment of the Maharashtra, High Court of Maharashtra, my lord, Mumbai, in Mihir Rajesh Shah versus State of Maharashtra. This is a criminal writ petition. I have a copy of that. Paragraph 20. What happened in this case? There was an accident and the car hit someone and the body was carried for a long distance. Now they took a plea before surrender. Everyone is coming with a plea in the High Court of the Supreme Court on the grounds of arrest has not been disclosed. So they came with a plea. A person was having alcohol, was alcoholic, he had alcohol at that time, he was drunk, he made an accident, his co-passenger was arrested, he fled away, and later we came with a ground for a quashing under 482 that he had no knowledge about the grounds of the what grounds he has been arrested, but he was fleeing out, he fled away. Now here it is stated in paragraph 22, it is in the background when we appreciate the pleading raised in the petition about the ground of arrest not been communicated, we must record that both the petitioners are conscious of the serious act of hitting the moped driven by the complaint, by the BMW car which was being driven by Mihir Shah with Raj Rishi sitting next to the driving seat and the car being driven in a rash and negligent manner with Mihir having consumed alcohol when the mishap occurred. Instead of rendering assistance to the complainant and his wife, the victim of mishap, the accused person chose to drive the vehicle continuing the high speed till the time when the vehicle broke down. Sufficient evidence was available on the first day of the incident. There was CCTV cameras. Here we have the video photography. There they had the CCTV footage. Here we have the video photography. That's why the reason why, my lord, the video photography was made mandatory, my lord. On the previous case, my lord has given an observation. Videography was not done. And if it is not done, the reasons has to be very much there. So collected from different location, as far as the petitioner Rajshi is concerned, he apprehended and he was found along with the car, and his passenger was apprehended. He was arrested, but even he had no knowledge about the grounds of the arrest. So now this is, my lord, and this case was challenged before the by filing of SLP before the Supreme Court. So there were 3 matters were taken together in the Supreme Court, and that is also I'll be giving a copy, my lord. This is SLP criminal number 17132 of 2024. And the bail, interim bail for this Mihir Rajesh Shah, it was rejected. No interim stay or interim bail was given. But in other 2 accused persons, this is on the grounds of arrest, this was taken. Supreme Court has, at the time of SLP, the grounds of arrest, and the matter is still pending. It's not that it has been decided. But the thing is that the intention of the Supreme Court was very clear. They have not granted any interim order or bail to the accused person. So they were going to pass, obviously it's pending. Till now, I've checked, my lord, till now no such order has been passed. So here is my written note. That's what in this case, and in conclusion, but there are some general things which my lord knows very well. First of all is that in this type of cases, my lord, 3 things has to be three things has to be considered. While we oppose first the gravity of the offence of the NDPS Act, that has to be taken into consideration. Societal and national impact in these cases, stringent bail provisions under section 37, the bar, and balancing constitutional right and public interest, that has first to be taken into consideration. Because whatever order my lord will pass, it will be followed by all the high courts as in the country matters. And protection of constitutional and statutory rights.
So
Right of
when he was produced before the London magistrate, or
was
that
produced the city.
because he might have been produced before direct the NDPS court only.
That will check. Was arrested, search and seizure was done in presence of an executive magistrate. He was arrested on 28 March 24 at about 20:15, that is night, at about 8:15 hours. At that time, the court was closed. Seizure list was prepared.
When he was forwarded to the London judge,
Then there are witnesses, 161 statement of the witnesses.
that is during that, when he was produced, and what was the forwarding report before the magistrate.
He was produced on 29 on the next day.
What
And this is the forwarding report. So this is একটা
কেন দিলাম না তোমাকে ইয়ে?
আমার কাছে রিপোর্ট দিল
আনরিপোর্ট
আনরিপোর্ট নাকি
আনরিপোর্ট কপি দিয়েছি সই করে নিয়েছি আমি যাবো রিপোর্টের কোনটা রামকিশোরের ওরা তো
দাঁড়া দাঁড়া দিচ্ছি সব দিচ্ছি
What is the name of the petitioner?
সুধার মন্ডল
How many accused persons are there? Two. How many petitioners?
two
are there?
accused.
Two accused persons are there.
না না
Three.
One granted benefit.
When you have been arrested?
28th March.
28? Huh?
28 March 2024
আর এই যে দুইটা কাজ করিস না তখন
Where is this arrest memo?
It's in the
Show me. Again, this petitioner's arrest memo.
car. You know, there's Mubarak Sheikh. See the list. आगे হবে। Yes. Yeah, they have never taken the plea, this plea, even with the trial peoples. ডাক্তার ওষুধ পারবি ডাক্তার ওষুধে পারবি না
Yes.
Yes. My learned friend has taken some points that I'll be referring to, replying to them in brief. But he says, as soon as possible, that means he says that there is no specific time limit as to when it has to get communicated. Now, Lord, the judgment cited by me, Lord Pankaj Bansal, and more importantly, Lord Praveen Purkas. Lord, it says that the purpose of serving the ground is that the accused person may consult with a legal practitioner of his choice and Lord may apply for bail. So, Lord, that means it has to be mandatorily served before the first remand application is moved by the prosecution. That was the intention of the Supreme Court, Lord, in Praveen Purkas. So, Lord, his contention, Lord, that it has to be supplied, Lord, as and when the prosecution wishes, Lord, that should not be the case, Lord, before your Lordship. Next, Lord, says not required to be given in writing. Lord, there are specific provisions of the Honorable Supreme Court, Praveen Purkas, Lord, I have cited on earlier occasion that it has to be given in writing. Though in Bihan Kumar, Lord, the Honorable Supreme Court has said that if it is not practically possible in almost all cases, but when the accused is alleging that it has not been given, so you have to do it in writing so that you can prove it that you have complied with the provisions of Article 22. Now, Lord, in this case, I am before your Lordship, I am saying that this has not been complied with. So, Lord, it is for the prosecution to establish that yes, they have supplied it to me. Lord, oral communication cannot be proved.
When you apply, on the first date, have you appeared before the trial, before magistrate, when you have been produced before the appellate court?
Lord, I was arrested and produced.
Arrested, produced. Have he has engaged the lawyer on that day?
Yeah.
Or he has prayed for the learned court, magistrate court to provide the legal aid?
Lord, that instruction has to be taken, but even if
No, because why I'm telling, they are
Yes.
forwarding a report which has been accepted by the magistrate, it categorically stated explaining him the grounds of arrest. under the proper memo.
So, my lord, that has to be established, my lord.
That's why now the Supreme Court, that's why what the judgment you have relied upon, in that judgment, the Vivan Kumar, not Vivan Kumar.
Let them show it from the case diary that they have
So
served.
that's why I'm telling in the case diary, that's why you ask for the forwarding report. In the forwarding report from which you have been placed, produced before the learned judge, it is mentioned that it was forwarded. That's why I'm asking you whether on the very first day when you have produced before the learned court, whether you have appeared and your advocate had appeared on that day or not. That is the crucial point. Is.
Must have appeared.
So if you are appeared and you had the knowledge with regard to this forwarding report, because what happens if the accused been arrested, once the accused is produced before the magistrate, the lawyer who is appearing before the London magistrate for filing an or judge for filing an application, that is the first duty or doing that the bail advocates who is moving the bail application, the first they will go to the forwarding letter which has been filed before the magistrate. What are the ground mentioned in that? And on that only you can make an application, you can argue before the court with regard to the what is the lacuna on that. And as per this ground, as per this forwarding report, it is mentioned. That's why I'm asking you.
That is one aspect, my lord. I have to take instruction. That is one aspect. My lord, the advocate for the accused, my lord, whether he goes to the court, he sees the remand application or forwarding application. That is one aspect. My lord, the main part on which, my lord, we are before your lordship.
Correct.
Is that the duty of the prosecution to supply.
That's why the court has to satisfy.
Lord.
That's why I asked the PP also.
Lord.
See, with regard to 21-1 is different facts. In each case is having its own fact.
Well.
Correct. Sometimes the police are having the small thing arrested in mention. Something it is a big case arrested in the forwarding letter it is mentioned. Sometimes it is mentioned in the case diary they have mentioned he has been arrested and the relative has been informed he has been arrested for the offense so and so so and so. So each fact is having because there is no guidelines. This yes in the custody memo or in the arrest memo this has to be given. It has to be implied. Court has to satisfy the provision whether it has been complied by the police or not. Court has to satisfy only to that effect. If the court find that it has not been complied with, then you are entitled for it. If the court find that it has not been complied with either of the document or in the arrest memo, then you can get the benefit. That's why I'm telling each case is having its own. Suppose. Because why? Suppose if the person allegation has been made and police has brought the person in custody, he has kept for the 3 days, and after fourth day he has been produced. You made an application that he has been brought in the police for the 4 days or 5 days, and now 6th days he is producing. So that for that it is very necessary to go through the arrest memo. What are the necessary? What is the GD entry, and whether it has been informed to the petitioner why you have been brought to the Hana. With regard to this case, now from the documents, court has to satisfy. Court has to satisfy. That's why I'm giving an opportunity. You go to the forwarding note and see the first order of the London magistrate whether the advocate has appeared or not. Because 22(1) what says? Why it is to be informed. So your legal right cannot be curtailed. It is not that he has been arrested, sent to the police, sent to the custody. You are not aware, neither your family members are aware. That is the thing. If you have been aware, you are appeared, your advocate is appeared, so you cannot say that I have not been informed, and during the hearing of the bail application, you can say, sir, kindly see the arrest memo, it is not been done. So that's why you have to satisfy this is not the provision, this is the provision which the accused could not able to find that there is any report, arrest report which has been or justification has been given to the accused with regard to the arrest. Kindly see the Vivan Kumar, you have relied upon, just I have gone through.
Signature of the brother of the arrestee.
That's I'm telling, that's I'm telling. The court has to satisfy.
Something which has to be interpreted in the way. this
Correct,
court has said.
correct.
Now, my lord, Supreme Court has categorically distincted between reasons of arrest and grounds of arrest. Because reasons of arrest is common for everyone. That I shall not tamper the witness, Lord, I may have, I may tamper the evidence, I may tamper the witness, I may abscond. Lord, these are the reasons for which, Lord, I have been arrested. But the grounds of arrest are distinct, Lord. That has to be different from person to person in a single case.
Yes.
In a case, there may be three accused persons, but the
Yes.
grounds may not be same for the all three accused persons. So, Lord, here, Lord, it is the imperative duty of the prosecution to tell me under what grounds I have been arrested.
Yes, kindly come to, you relied upon the
Okay.
Viman Kumar.
Yes.
Correct. Viman Kumar, kindly come to the conclusion portion after paragraph 20.
Lordship.
Paragraph 20. Conclusion, 21, conclusion B.
My lord, my lord.
Conclusion B. Kindly read that. The last line. The mode and method of communication must be such that the object of constitutional safeguard is achieved. Got it? 21,
21.
21B.
21B.
21B last.
Yes, yes.
The mode and method of the communication must be such the object of the constitutional safeguard is achieved. So what is the safeguard under 22(1)? So that you cannot be, the person who has been arrested cannot be curtail the legal right which he is having after the arrest. Correct. That is the. So you have to satisfy due to which he cannot engage or he has not having the knowledge. Because as per the forwarding letter, this is mentioned. You can,
In the forwarding letter, they have said that they have informed me the grounds of it. But there must be some document, Lord, that they have informed to me.
Okay.
It has to be countersigned by me or my family member.
Okay.
Something. Lord,
Yes.
kindly see para 26 of Bihan Kumar.
Yes.
Para 26, the stand taken before the High Court was that the appellant's wife was informed about the arrest.
Correct.
Information about the arrest is completely different from the grounds of arrest.
Correct.
The grounds of arrest are different from the arrest memo.
Correct.
The arrest memo incorporates the name of the arrested person, his permanent address, present address, particulars of FIR and section applied, place of arrest, date of time of the arrest, and number of the officer arresting the accused and name, address and phone number of the person to whom information about arrest has been given. We have perused the arrest memo in the present case. The same contains only the information stated above and not the grounds of arrest.
Correct.
The information about the arrest is completely different from information about the grounds of arrest. Mere information of arrest will not amount to furnishing grounds of arrest.
Correct. That's what I'm telling. See, you persons are telling that and showing that the arrest memo there is no ground. But under the CRPC or there is no rule frame with regard to the information is to be in writing. That is still in dilemma. It's still in dilemma. Correct. Correct. Now if you go by the arrest memo telling that it has not been mentioned that Vivan Kumar has already been justified to that. So how the court implied the information with regard to the arrest has been informed.
Now, Lord, in BNS also,
Huh.
section 36.
Correct.
Lord, so this part is incorporated even in the BNS. Section 36C. Lord, the time is.
Yes.
That every police officer while making an arrest shall inform the person arrested unless the memorandum is attested by a member of his family that he has a right to have a relative or friend or any other person named by him to be informed of his
So
arrest.
that is the information of the arrest. That is the information of the arrest. That always there.
Right.
Relative or locality, prominent member of the locality
Right.
or relatives. And countersigned by the person arrested. That always, that is the custody memo.
Giving it to the wife, so far as. in
No,
behalf-
no, that's I'm telling. That's why I'm telling. I'm not telling that the arrest memo, wife signed it is information. That is with regard to the arrest. With
Right.
regard to the arrest. With regard, that's I'm telling. So till date, even the BNSS has come after the amendment, but there is no form has been come or there is no rule framed. So this is the way, this is the form with regard to the information. So how the information, how the justification or information of the arrest or ground of arrest.
A new form is there in the BNS.
Sure, sure, sure,
There is.
sure.
Though it is in the arrest memo, reasons, grounds of arrest, but in addition to this, I have personally seen, Milord, there is a form specifying grounds of arrest.
কি বার করছে রাজেশ ছিল নাকি সোনালি শাহ ওটা তো ভুলটা কবি বার করছে
Yes. After this certified that the arrestee has been informed the ground of arrest.
Lord, in addition to this, there is one more Lord, form, a pro forma, Lord, I have seen it.
Where is it? Show me. And if it is so, that is in the amendment. It is not in the CRPC, I don't think. CRPC? CRPC? So how it has been connected here? Show me
That is.
CRPC.
চেষ্টা করে যাচ্ছে
I might be wrong.
No, no.
I
You are
might be
absolutely
wrong.
right, my lord. Absolutely right.
I might be wrong.
হ্যাঁ বুঝেই বলছি ওরাই সব শুধু
Lord, this is under CRPC, so let's not get into that. Lord. In BNSS, that is there, but this case is under.
Correct.
So, Lord,
So that is the that is to be ascertained. This is to be ascertained with regard to, so how what they have taken the ground, whether the court can imply it has been informed, ground of arrest has been informed. Reason for arrest is informed. That is to be seen. Now there are several judgments. Anything further you want to add?
no, Lord, I have given, all the compilation is there, Lord. I have given my written notes as well.
Okay.
I have given my written notes as well, Milord. Only thing, Milord, which I left out, Milord, as my learned friend pointed, that section 35 presumption he was referring to, Milord. Milord, presumption is there in all the statutes. Milord, it doesn't require. Gravity of the offense, Milord, is also not required to be answered. And Milord, so far as the Bombay High Court matter, Milord, he has referred. In that matter, 3 accused person has been enlarged on bail. But my learned friend is very well prompted, Milord, in not handing over a copy and only reading out the relevant portions. But Milord, the 3 accused persons are on bail in that matter. Milord, Ram Kishore Arora, the only judgment of the Supreme Court he was referring to, that has been diluted in Purgas, so Milord, specifically. So Milord, he did not Milord, touch upon the other judgments I have cited, but he has only taken up Ram Kishore Arora, and Milord has read out specific portions out of it, Milord, which has been subsequently diluted by the Honorable Supreme Court. So this is my Milord humble submission before your Lordship, Milord, will kindly consider the judgments and my written notes, Milord, and may pass necessary.
Thank you. Thank you. You do one thing. This is original. Again, you have a certificate. No. What is the stage of the? He is on bail.
No.
He's on.
I'm paying for this.
What is the stage of the trial?
Charge.
Only one witness has
Only
been-
example.
When the next date is fixed?
Two witnesses have been.
I don't know whether I can pass the judgment within these 2 days. All the judgment has to.
Keep it up to Friday. If not, then Friday, in the meantime, we'll ask for the certificate.
Okay. I am keeping it. If I find that I am able to judge, I will judge. I am keeping this. If it is over, then it's otherwise, then you have to give this.
Lord, next date is fixed for examination of the second witness, PW.
18? 18?
18 June.
Already there's an order, I have already given the last one, which is my last order in this. Considered and rejected.
No.
The report.
Unreported decision.
No, that I have not decided. Only a oversight I have given that. So and so suffering for the petition, so and so suffering for the state. Hearing concluded, CAV.
Great.
Thank you. Yes, next. हाँ से क्यों 68 पहले दूसरा तो बुलाओ ना 66 तो बुलाओ 64 भी है वो अभी क्या केस बुलाएगा बुलाओ दो
Mother 65, I'm for the petitioner, my lord.
Yes.
Mother, this is for extension of interim order. My lord, the initially the interim order was granted.
Please keep silent.
Copy of.
Yes.
My interim order was initially granted for 6 weeks, my lord, which expired on 10th of March, my lord. And on that date only the application was preferred. And on that date only the application was preferred, my lord.
But copy of the CRAN has not been served upon the state.
It has been already served, my lord.
To whom you are served?
Upon the state and the opposite complainant, my lord, opposite party number 2.
Take that.
And on 10th of March, the application was filed, my lord.
Lord, that is the main revisional application, Lord.
Along with the CAN.
Have you filed the supplementary? Give supplementary disclosure.
Yes, my lord, the supplementary has been affirmed, my lord. My lord, my junior is there, my lord. He will hand over the copy, my lord. I've annexed
Nobody is
the.
there on your behalf, sir.
Yes.
Nobody's here.
My lord, then kindly passes it over, my lord.
Pass over. Next.
I am for the state. 66.
Yes.
I am for the petitioner.
Yes.
This application is challenged.
Please, you both go outside. You go both outside and chat in the outside, then come when your chat will be completed.
The de facto has come.
Yes.
It will be de facto. But it is a challenge against the case instituted under section 138 NI Act.
NI Act.
Lordship,
You are for the?
I am for the accused in the.
Yes.
But what happened was when the there was certain, I'm just giving you the facts of the matter. Admittedly, a check was given to the complainant, but after the check was dishonored and prior to the institution of the complaint before the trial magistrate, the accused had paid some amount from the check amount. But the complainant went on ahead and filed the case of the entire amount of the check.
Correct.
That matter is bad.
Why?
Because my lord, the Honorable Supreme Court says so.
You prove that, prove in the trial.
No, my lord, it is palpable.
No.
My lord, these are the payments that were made.
Now, so the Supreme Court judgment, it has to be considered.
So this is the 2023 judgment.
Yes.
Lordship and paragraph 30, their lordship
Paragraph?
30.
Yes.
In view of the discussions above, we summarize our findings below.
Hmm.
For the commission of an offence under section 138, the check that is dishonored must represent the legally enforceable debt on the date of maturity of the presentation.
Correct.
If the drawer of the check pays a part
Or whole.
or whole of the sum between the period when the check is drawn and when it's encashed upon maturity, then the legally enforceable debt on the maturity would not be the sum represented in the check.
Correct.
When a part or whole of the sum represented in the check is paid by the drawer of the check, it must be endorsed on the check as prescribed in section 56 of the Act. The check endorsed with the payment may be used to negotiate the balance effect.
Correct.
If the check that is endorsed is dishonored, when it is sought to be encashed upon maturity, then the offence under section 138 will stand at fact. So in this case, my lord, the payment was not endorsed on the check.
When you have paid the last amount, what was the total amount of the check?
9,50,000.
9,50,000. Correct. And what amount, what is the last amount you paid in total? What is the total amount you paid?
Around 4 lakhs, my lord.
4 lakhs. 4 lakhs you paid.
Sir.
What was, when the last amount was paid?
Last amount was paid.
When the last amount was paid?
16 September 2023.
16 September?
2023.
Sure.
Lordship, I have supplied you the entire payment.
16 September 2023. And when the legal notice was issued?
March 2024.
Huh?
16 March 2024.
16 March 2024. By 16 March 2024, how much amount you have paid?
But we have till now paid
No, till now. Before issuance of the notice.
for that 4 lakh.
No. When notice was issued on March.
March 24.
March 24.
Yes.
16 March.
Yes, master.
16 March.
Yes.
2024 notice issued.
Lordship.
In the notice, what you have claimed?
Full amount.
Full amount.
How you can claim?
No, they did not give any money, my lord. Did not give money, and they reply in the said notice. They reply.
They are replied.
Yes.
Where is the reply?
Kindly, they have not annexed all the documents.
Where is the reply?
Well, this is 30%. They admitted.
Yes, admitted. We
Admitted.
have to check.
No, have
No,
you
admitted the amount.
you have stated that paid amount has been paid. No, nothing is relieved.
Can you see the reply?
2 checks were issued in favor of so. Dodging so. My
But they
client
did not
never
receive
had
the
the
amount, then I
intention
filed the
to cheat
complaint.
your client regarding the payment. As due to unfortunate circumstances, mismanagement of saving in my client's account, the checks were bounced and my client's wife is nowhere in nothing to do. My client declared the community. My client has no intention to prolong that within this time. Okay. You pay back the was a amount to you because. Yes, you not stated anything. So you have to prove in the trial.
But this instruction was not, even the advocate.
Might be.
But my lord, the fact remains it was paid.
No, sir, you paid. If you have,
My lord,
if
we
you
have taken
are
this
not
before the trial court.
correct, if you have not given the reply, then the court can take the presumption. But you have given the reply. In the reply, you have stated that last payment was made on 9th of September 2023.
Yes.
He has issued the notice on 16th of March 2024. You have sent the reply on 3rd of April 2024, admitting that you are not, your wife is not in a position to pay the amount, and he will pay the amount.
After the complaint was instituted, we had brought this matter to the notice of the trial magistrate. He rejected our plea.
Correct. Correctly, yes, he has rejected, or he has rejected. Because you have, if you have paid, you could prove in the during the trial at the time of cross-examination, because you have not, if you have taken the stand in the reply to your 138 notice, then it can be said that he cannot file the suit, file the 138 application for the whole amount. He can file this application for the rest part amount. But you have stated, kindly see your notice.
My lord,
Might be having misguided.
My lord, now let me point out one. The admission made by the advocate will dedicate the statute.
Under instructions of my client Anil Lama.
I am accepting the notice.
Correct.
Even then, I am now my submission. A wrong admission made by the advocate.
Not at, now here is question of not admission. Here the question of this court is not taking the trial. This now the here is only the question with regard to the amount which you are taking the plea that the amount has been paid, but in spite of received the amount, he has claimed the total amount, ignoring the amount he has received, and he filed the suit. As per the judgment of the Supreme Court, you cannot file the suit. Correct. I totally agree with you. I totally agree with you. But yes, but that's why I put the first question to you. What is the total amount you paid? What was the last amount you have paid? You have paid the last amount on 16th September 2024. On 2023. 16th September 2023, you out of the 9,50,000 as claimed by the 9,50,000 as claimed by the complainant, you paid the 4 lakhs. And he has issued the notice on March 2024 after about 7 months. After 7 months, and you have not stated in your reply, sir, your notice is wrong. I have paid this much amount, which was legally recoverable, and it is not.
Right, my lord. My lord, now my submission. I did not properly respond to the notice issued by the complainant. Now that is one of the basic ingredients of 138. My lord, the case has proceeded further. Magistrate rightly, wrongly has taken cognizance, issued process. I appeared. Now, my lord, now after I appeared before the trial court, law gives me a chance to explain that this case cannot go against me because it is hit by law. I may not have responded to the advocate's notice, but now I have come to.
Correct. I am telling. If you are not have been responded to the advocate notice, your defense could have been taken into consideration. Yes, this amount was paid, but he has not come with the court with the clean hand stating that. But you have given the reply. But you have given
No,
the
my
reply.
lord, my lord, one thing, they had filed an application under 143 for interim payment. That was rejected by the magistrate
Maybe.
on the same ground that we have
Maybe.
received payment.
That's why that is not mandatory.
No, my lord,
143A is not a
my lord,
mandatory.
my submission would be, my lord. I did not, I responded wrongly to the notice of the advocate.
Maybe.
So long he was not in the, though he received the money, surprising, he says that I have not received. Bank transfer to his account, he said I have not received.
Correct.
He still retains the right to come to the court to file the complaint.
Correct.
I appear before the court.
Correct.
I have a right to tell the court that the cognizance that you have taken against me is wrong.
Correct.
Because as per the law and as per the Honorable Supreme Court judgment, case cannot proceed against me. Learned magistrate rejects my petition.
Where is the order of the magistrate?
Yes, against the order you have submitted the order.
No order has been challenged before court. No order has been challenged.
It is there. Certified copy. Order dated 25th February 2025.
Last day.
It is,
No, it is your order for 143A order. Where is your order challenging that? Where is your order? What application you have filed? This is the order of the 150, 143A. That is their application.
Yes, my lord.
Where is your order?
Before the child, what happened to that?
No order. What application you have done? No application is there. Here
My
challenge
lord,
143A.
I humbly pray that my lord case it tomorrow. We have not annexed the file supplementary report.
Come tomorrow, but I don't think so.
So, my lord, let me satisfy your lordship's concerns that
No, why I'm telling, now you're taking the plea with regard to, the notice issued by the advocate cannot be admitted on behalf of the client, correct? But if the notice has been issued in the 138 application, if you are challenging the notice, then you have to prove during the trial.
challenging the notice of the advocate.
Then you're telling that the advocate has not been given,
No, my
he
lord,
cannot admit that.
I am asking your lordship to consider the situation that the complainant's advocate made a demand notice. Without the demand notice, 138 is not activated.
Correct.
So I can respond, I cannot, may not respond.
Correct.
I have responded in a wrong way.
Correct.
Now I am not challenging the advocate's notice. I am challenging the proceeding that is running against me on the ground that the check that is before the court does not reflect the legally payable debt. And that is one of the cornerstones of 138 proceedings.
That's why that is to be proved. That is to be
No,
proved.
only thing that I have to bring before your lordship is that my application asking the court to discharge me from the case.
Where is that order? Where is
But
the
I will
application?
analyze-
Where is that order?
I will answer my lord, I will get a copy.
Because you are not disclosed any. There's a- Not today.
Change
Today,
of vote.
not today. This, so and suffering for the petitioner. So and appearing for the opposite party. Counsel for the petitioners has argued at length and prayed for time to produce the copy of the application and the impugn order passed by the London magistrate rejecting the application filed by the petitioner. Let the matter be listed tomorrow at the top. Yes.
A change of
Yes.
role, my lord. Change of role.
Yes. Who is for? You are for the complainant petitioner, sir? Yes. What is the application for?
I have challenged a particular.
Acha, that,
Yes.
that one, proclamation.
Yes, proclamation order.
Have you obtained the order?
No, Lordship, I have-
Obtained the certified
No,
copy?
Lordship, I have applied for, will take time, Lordship.
What you applied for? The report submitted by the,
Submitted by the.
that is required. If that report fine, then only your case will be.
My lord, two things may I be permitted. My lord, earlier there was one CRR 27 of 2024, which challenged the ER and proceeding, this proceeding, ER and W order. That was dismissed by the honorable court. And my lord, if your lordship permits me, we have a copy of the proclamation.
Report you are having?
This is a proclamation order, my lord. It clearly states where, when, and this is the report, my lord. This is the office copy we have taken out. But it clearly states where to come, at what time to come, and which date to come. Take copies.
Yes. That's why I'm asking. It is there.
This is the first time that I'm going through that I'm inspecting this, also I have to take instruction.
What instruction? It is the
No,
report.
because it will communicated to the accused person on within time or not, I don't know. So I have to take instruction and I have to take.
My lord, kindly consider the.
Communication, how the communication can be made? It is, you are warranty. You are absconded. How you, can your application, your petition?
My house at least.
Yes, it is there.
Reported.
It is there. You cannot challenge, sir, all the things.
No, sir, because all the thing is also it is unless.
My lord, it was pasted on his
Correct.
residence wall. Everything, my lord, we have annexed the photographs also.
This DD case, has been entered, NDPS.
My lord, it was pasted on his residence wall. Everything, my lord, we have annexed the photographs also.
This DD case, has been entered, CIPS.
On 14/6, the permission of Assistant Director NCB Siliguri Journal IO along with the NCB team reached this Sitai police station for execution or affixing the proclamation notice against the absolute so issued by so. On 14/6, IO met the CHO Sitai police station and submitted the requisition for assistance in carrying execution. All the things are there in the report.
Honestly, I'm telling you, I have to take instruction whether this notice was put in the, affixed in the house or not, and that has also been.
Sir, you are abscond, how you can say?
In my house or not, I have to take instruction. That only, that is my humble prayer also. Let me.
Today also, yesterday also you suppressed the material, today also you suppressed the material. So,
this is the new thing that has.
what is the new thing here? 27/4/23/7/2020, it is not the new document.
The last day hearing, day before yesterday also, I have applied for 35 copy.
Sir, I am as a friendly requesting
Yes,
you,
Lordship.
please don't do this type of the practice before the part of last 3 dates, Mr. Majumdar, you are the senior person of this bar. Last 3 dates, I am finding this person misleading the court in each and every cases.
It is perhaps, Lordship, I misunderstood me, Lordship, this is.
3 dates I have noted this person. One case I have put the cost upon him also.
Lordship, perhaps.
And if you have say further something, then I have to again you have to take something action by this court.
Perhaps, Lordship, I misunderstood me, Lordship.
Whenever yesterday also he has challenged the SDM report. When the SDM report has come from his file, I got the SDM report. Yes, there is an order and the notice was issued. But he has suppressed that fact that is not enclosed in the application. Yesterday also, this application was heard on 21st, 2 days before. Until that your advocate record has not able to get the what apply. You could have been inspect the file.
Since Lordship has submitted, Lordship was telling me that you have to.
Record and order.
That's why I have applied for.
So offering for the petitioner. So offering for the offering for the state. DSGI is offering for the ACB. Full stop. The petitioner has filed the present application. Please don't do this type of practice, sir, in the High Court. Not in the High Court, in any of the courts.
I'm honestly submitting, Lordship. I have no.
In the principal bench, I told the bar, I am allergic to the 2 things. One is with adjournment, second is the misleading. If this court finds these 2 things, it's very difficult to the advocates to come out from that.
Lordship, I don't take me amiss, Lordship.
And this is a 3rd case you are doing that.
Lordship, don't take me under misunderstood, Lordship. Why I'm telling Lordship, you ask me any of my senior friend or any of my friend, Lordship. I don't realize all these things in so yesterday, Lordship, so far yesterday's conduct is concerned, I was fully covered with a particular judgment. That's why I advised my client to file this application. Even the requirement of 111 was not there in explicit term. That's why I filed the revisional application. That is brought on record before your Lordship. Lordship took an otherwise view and passed the order. So I have nothing to do with that. Lordship, today itself, even Lordship, if I say, Lordship, that whether the notice has been put in his house or not, Lordship, I have to take instruction. This much submission I have made, Lordship, before your Lordship. It is up to your Lordship. I have not seen that.
Again, you are missing. You are absconded accused.
Yes.
Correct.
Absolutely.
Warrant is issued.
Yes.
The police is not able to, or NCB is not able to arrest you.
Absolutely.
Subsequently, the NCB filed an application for proclamation. Proclamation issued.
Yes.
Proclamation issued. This report as they have complied with the proclamation. Now, if you are abscond, how you can say you can challenge this report of the NCB?
No, I am saying only. I'm repeating, Lordship, what I am saying. I am submitting that this my learned senior friend is submitting one copy of a proclamation, a notice that I am to require to appear before the particular court at a particular day and time. This is the notice that my learned friend is handing over. I am submitting that whether this notice was affixed in my house in my absence or not.
But
that particular instruction.
That is not the case made out in your revisional application. You are not challenged it. You have directly stated that no procedure has been followed. Now the court has found the procedure has been followed. So now you can challenge again in the revisional application or steps is to be taken.
No, my submission is that the impugned order itself does not, does not conspicuously statically see 21, impugned order date 21st of May, impugned order. It does not clearly indicates that this particular notice was indeed affixed in my house. Requiring me to appear before the court. That is the violation I have.
What?
That the impugned order 21st of May 2024 does not conspicuously indicate that I am to appear before the particular court on a particular date by pursuant to a notice being affixed.
Sir, so what the procedure says, if the particular court has issued the WPA and the investigating agency has to comply with that, the notice which has to be affixed by the investigating officer in that all, you knows which court, and the investigating officer already narrated the date, time and the court, and you know with regard to the which court your case is pending.
Yes.
Then
No, unless I am.
whether
saying-
court has again has to pass an order.
Perhaps I am failed to make you understand. I'm repeating your lordship. I'm saying that the
क्या
impugned
बोला?
order.
Suffering for the petitioner.
May I complete? May I complete?
Suffering for the NCB. Police of consequence, the petitioner has filed the present application challenging the order passed by the Leonard Special Judge, Leonard Additional Session Judge, First Court at Food Bihar, in special case number 45 of 2023, arising out of NCB crime number 25 NCB Kolkata 2023 under section 21 within bracket C within bracket /22 within bracket C /29/8 within bracket C of the NDPS Act 1985 dated 21st of May 2024, wherein where is the 21st of May 2024 order?
At page 24.
Huh?
24, page 24 of my application.
Wherein the London Trial Court has issued proclamation against the petitioner and proclamation against the petitioner as the warrant of arrest issued against the petitioner would not be executed. And as per the prayer made by the investigating agency, the London magistrate and the London trial judge has passed an order for issuance of proclamation. He submits that in the impugned order, the London judge has not given any reason and has also not given the details where the petition has to appear, on which date the petition has to appear. Simply, the London judge has passed an order for issuance of proclamation, and as such, the order is liable to be set aside. Police counsel for the petitioner submitted while issuing the order dated 21st of May 2024, the London judge has not complied with the provisions for issuance of proclamation. Per counter, London advocate appearing for the per counter BGSI appeared on behalf of the NCB has submitted the notice and submitted the copy of the proclamation and the report submitted by the investigating agency before the London trial court dated 23rd of July 2024, wherein it reveals that on 14 June 2020, wherein it reveals that on 14th June 2024, the NCB team reached Sitai police station for execution / affixation of proclamation notice issued against the petitioner by the London trial court dated 21st of May 2024. It is further reveals from the report that on 14th of June 2024, IO met the CHO. What is CHO? SHO, it's CHO recorded for paragraph 7 of your report. What is the CHO? Paragraph 7 meant SHO or CHO?
Nothing is your lordship grade. Nothing is missing. I don't think that.
Putting the IO met with the officer in charge of Sitai police station and submitted a requisition for assistance in carrying out execution affixing of the said notice. Full stop. Said notice. Full stop. In the report, it is further revealed that after a combined team of NCB and the police personnel of Sitai police station reached the address of the accused petitioner at about 7:30 hours on 14 June 2024, and as per the direction of the Leonard Court, the said proclamation notice has been affixed in front wall of the house in presence of the team of the Sitai police station, and signature of the concerned witnesses have been taken. Full stop. And in the report, it is also mentioned that the NCB team along with the Sitai police station returned to the Sitai police station at 20 hours at 14 June 2024, and submitted, and a GD entry has been lodged. GD entry has been lodged. Full stop. The copy of the proclamation and the report submitted by the NCB agency and NCB agencies to the court has been supplied to the Leonard Counsel for the petitioner. After going through the said notice and said report, the Leonard Counsel for the petitioner raised the allegation that he has to take instruction whether the notice is pasted in the said in front wall of the house of the petitioner or not. The counsel for the petitioner further submitted that in the order there is no mentioning which place and which date the notice is to be pasted and on which date the petitioner has to appear before the court. Consider the submission made by the counsel for the respective parties, peruse the report and the proclamation notice. This court find that after the order of proclamation, the investigating office agencies has taken appropriate steps for execute the proclamation, and with the help of the Sitai police station within the jurisdiction of which the petitioner was residing, the notice was pasted and complied with the provisions of section 82. Thus, this court find that the application filed by the petitioner is not having any merit. Accordingly, CRR number so and so is dismissed. The report along with the proclamation notice be kept with the report.
Obliged, my lord.
Next.
Item number 17.
69-70 किसका पास है? किसके पास है? कौन? Who is the custodian? Court is the custodian of the document. So भेजो कौन है? टाइप कर भेजो मेरे पास, बुलाओ उसको, कौन फाइल जिसका पास फाइल. Yes. Item number 68-69 password because the file is not here. Wait, what is SS? What is SS?
68-69.
Ah. What Susanto?
Oh, server pending.
अरे यहाँ में एस क्यों लिखा हुआ है? कब गया सर्वर में? कब हुआ ऑर्डर? कहाँ है? लेके मंगाइए, किसके पास है? आई एम पासिंग इट टू कॉल द 70.
I'm in 70.
Yes. Who is for the petitioner? You. Who is for the petitioner 70? Nobody.
Let us appointment by court. Appointment.
What is the case? Quashing of the proceeding under section 498A. Who is the petitioner? Husband?
My lord,
Aunt? Sister-in-law?
my lord, regarding the petition number 1 and petition number 5 and 6 and 7. There is no such allegations, but rest of the petitioner, there are allegations. This is
Petition number 1 is the aunt. Petition number 1 is the aunt.
Madhavi Shah,
Madhuvisa is the aunt of the victim, accused.
my lord.
And petitioner number 2 is the sister.
Sister, his involvement is there. He de facto na petition.
Who is appearing?
Is for the defect.
There is no accused, is nobody is there. अरे बाबू ये फाइल नहीं दिया क्या? Paso. Huh?
I don't know, so that was court number 2.
Yes.
Or in this matter, there was a direction to my lord. The petitioner is praying for a leave to file a supplement to affidavit. My annexing of
Document.
Document.
लिखो ना आज रिसीव किया लिखो ना.
the case is start. The allegation of the petitioner
498A.
498.
Who is the petition number 1?
Petitioner number 1 is my lord the aunt-in-law. Aunt-in-law.
Aunt-in-law.
My lord. Petitioner number 2 is the sister-in-law.
Yes.
Petitioner number 3 is the husband of the sister-in-law. My lord. The sister-in-law and husband of the sister-in-law, my lord, both reside 40 kilometers away.
Then 4 is
4 is my lord the sister-in-law. That is the kaka to nono.
The defect.
yes.
And petition number 5 is the.
She is unmarried. Residing with the petitioner.
No, petition number 4 is the married. Petition number 5 is the younger sister-in-law. She is unmarried. Petition number 5.
Sister-in-law.
Yes. Petition
And
number
6
is the uncle-in-law who is 62 years aged.
uncle-in-law.
62 years.
And then
And my lord, petition number 7 is the husband.
husband.
Yes. My lord, the allegation of the opposite party number 2 is my lord that she was subject to mental and physical torture from the date of his marriage and subsequently on 27th of November 2024, my lord, she has been physically tortured physically and mentally, and my lord, subject to my lord administer some stupefying things, my lord. That is why my lord, section 328 has been my lord abstracted. And my lord, thereafter she did not make any complaint. My lord, 27th of November allegation did not make any complaint. Thereafter, my lord, on 5th of December 2024, the petitioners have been called the opposite party number 2 along with his brother. They came to our home for a shalishi. No shalishi had been held as per the allegation of the opposite party number 2. All the petitioners, my lord, beaten the opposite party number 2 along with his brother. That is the allegation. My lord, thereafter, she did not make any complaint. My lord, out of nowhere, he make a complaint on 31st of March 2024. My lord, almost after the 90 days, my lord. That is the allegation. And my lord, at the time of bail application, and my lord, in the charge sheet, there is a no mention of stupefying things, as because my lord, no medical was corroborated and no medical even been collected, my lord. Now, my lord, if my lord, kind of supplementary evidence, my lord. My lord, page 7. Page 7 is my lord, the 161 of the brother.
Yes.
My lord, 8th line on 27th of October 2023 আমার ফোনে কল আসে আমি জানতে পারি ময়ূরীকে রাজু শাহ ওর ফ্যামিলি মেম্বারসরা মিলে মারতে চেষ্টা করে. There is no mention of stupefying substance. And my lord,
Kindly see the date, my lord, 27th of October 2023. In the FIR, it is
Who is
mentioned,
he? Statement of
he is the brother of the informant,
brother of the informant means
brother of the wife, my lord.
brother of the victim,
Brother of the
wife,
victim.
brother-in-law.
Brother. My lord, he mentioned in 27th of October, my lord.
Yes, when the FIR was chalked out,
FIR was chalked out 31st of March, my lord.
31st of March
My lord,
24.
13th of March.
13th of March 24.
24.
Yes.
And my lord, in the FIR, the incident was occurred as per the FIR on 27th of November. And in their, my lord, 161 statement, they all, my lord, stated the incident occurred in the October, in the month of October. But in the FIR, they have been stated in the month of November. My lord, there are serious laches, my lord, in the part of the prosecution. And my lord,
So this is the brother's evidence.
this is
On
the brother-
27 2023 আমার ফোনে কল হয়েছে যাতে কি
তাকে
কে
আমার
রাজু
বোনকে
শাহ
মারতে
আর
চেষ্টা
ফ্যামিলি মেম্বার্স
মারতে চেষ্টা করে।
মারতে চেষ্টা করে।
Just only. And my lord, thereafter on গত 5/12/2023 তারিখে কাউন্সিলররা নিয়ে মিটিং হলো,
হ্যাঁ
আমরা ময়ূরীকে সংসার করবে বলে মেনে নিলাম, আমাদেরকে ডেকে ঘরে কিল ঘুষি চর মারে, লাথি মারে, my lord. My lord, who assaulted, there is no mention. And in the FIR, there is 7 person accused, my lord.
yes.
The brother of the,
How many witnesses are there
only 3 witnesses, my lord.
in the charge sheet?
In the charge, there are 6 witnesses. One is my lord medical officer, one is scribe, and
Now
my
with
lord,
regard to the incident,
in regard to the incident, no witnesses, only 3 witnesses. One is my lord brother of the informant, that is the page number 6, page number 7. One is the mother of the informant,
Geeta Bhattacharya,
Geeta Bhattacharya, who
the
was
mother
not,
of the victim.
he is the mother of the victim who was not even present at the spot.
What is stated? She has stated anything in the
My lord, she has stated that on 27/10/2023, that is the month of October, my lord, they are written in the
তারিখে ওর মারপিট
হুম,
করে
তারিখ-
কিন্তু জল কিছু
দলে কিছু মারাত্মক জিনিস,
তো ইয়ারসে
here's the my lord. He is not even,
she was not there.
she was not there.
Then what is the other?
Even my lord, in regard to the 5/12/2023 incident, she did not
She has not stated.
say anything. And my lord, there is a page 9, 161 of the Mayuri Bhattacharya, that is the my lord victim wife.
Yes.
My lord, she stated on
Who is he? Moini Bhattacharya?
he is the wife, victim wife.
She is the wife.
Mayuri Bhattacharya.
Victim. She is the victim.
My lord.
What she has stated?
On 7/10/2023 সালে আমাকে 1, 3 এবং 4 নাম্বার আসামি মিলে ধরে রাখে।
1, 3 and 4. He knows who is the 1, who is the
Yes,
2
my
and
lord. 1, 3, 4 is the, 1 is the my lord the husband, 3 is the my lord Madhavi Shah, that is the aunt-in-law.
Completely lying. ধরে রাখে, thereafter what happened?
Yes, my lord.
They took active part in
Yes, my lord.
administration of the poison.
27 সালে আমিকে
আমাকে জলে কিছু বিষাক্ত জিনিস খাওয়ায়। বাকিরা ধরে রাখে রাজু শাহ আমাকে জলে কিছু বিষাক্ত জিনিস খাওয়ায়। That is the allegation.
So, well, the involvement of everyone is there in a hostel.
but where is the corroborative? Where is the corroborative evidence?
At least corroborating,
My lord, if my lord, the date of incident has been occurred on 7/10, that is the after 4 months, and as per FIR, after 3 months they have been.
Where is the FIR is?
FIR is my lord page 5, my lord, of supplementary
On
evidence.
13/3/2024.
Page 6, my lord,
Page 6. There is a Bangla language.
Bangla language.
So you are not translated.
On 27/11/2023, উক্ত সকল আসামি একজোট হয়ে আমাকে প্রচন্ডভাবে মারধর করে।
27.
27/11. As per FIR, they mention the date 27/11. And my lord, as per the 161, it is mentioned 27th of October, my lord.
And a complaint was made on 13th March.
Complaint on 13th month, my lord.
13th
After
month.
more than 3 months. If my lord, as per the FIR, and my lord is, if my lord, as per the 161, is after 4 months, my lord. And there is a no delay mentioned in the FIR.
But my lord, in the FIR, the incident, all
Let me complete. I will come to you. Yes.
And thereafter, my lord. Oh, another thing, my lord. My lord, petition number 6, if my lord
At page 25 of my application. My lord, at that time petition number 6,
25.
yes, my lord, of my application. My lord, petition number 6 was with a moving train in Delhi, my lord. The PNR status has been.
Page number 25.
Page number 20.
Yes.
My lord, she was in the moving train at that time.
Who is she?
He is
Samiran
a
Shah.
62 years old, my lord, uncle.
What is her name?
My lord, Somiran Shah.
Samiran Shah.
Yes, my lord.
PNR. What you want to prove from here? 21/11/2023.
27th what he has been mentioned in the FIR, that on that time, my lord, I was in a train, my lord. 27th of 11.
PNR train, so and so 27/11, departure 10:35.
Yes, I was train.
But when, what is the time of the incident?
My lord, no time has been mentioned.
SL HMY, where HMY means
My lord,
where from?
it is a boarding.
Where from you are going? Where you have boarded and where you have to?
My lord, departure on Himalayan Somiran Shah Export for Indian Railway. My lord, the local train near, so far my instruction, at that time, he was in Delhi, my lord.
Delhi.
Delhi. My lord, thereafter, my lord, page 24. So page 24, my lord, Mitali Shah is the petitioner number 2. My lord, at that time he was under, my lord, treatment.
2011.
Yes, my lord, at that time he was under treatment.
27.
And my lord, he and his husband is, my lord, residing 40 kilometers away from the place of occurrence. My lord, the petitioner and his husband is only living in a house, and my lord, all other accused person is, my lord, living in a separate.
What about the mother-in-law, father-in-law?
My lord, there is no mother.
They are not the mother, father. You both only. Yes, that's all.
That's all.
Where is any medical report?
No medical report has been collected as per the charge sheet.
As per charge sheet, but they have not annexed it. Medical. How no medical?
Samiran Madhvi Monti.
Lord, may I?
Hmm.
My lord. About the delay, my lord, there is an explanation.
Hmm.
In the FIR, the last line of the FIR, সমস্ত ঘটনায় মানসিকভাবে বিপর্যস্ত হয়.
What is the date of incident?
But there is.
Please,
there is
please.
a date.
What is the date of the incident as per FIR?
My lord, 27/11/2023.
Correct. That is the FIR.
Yes, ma'am.
Correct.
No, FIR was the lodged later, my lord.
No, no, as per the FIR, the
Yes.
date of incident is
27/11/2023. The administration of poison, man. Thereafter, there is.
That's why I am coming. You are going to the another station before leaving this station.
My lord.
So I am telling that as per the 27/11/2023 is the place of date of occurrence. Correct?
My lord.
Date of occurrence. There is no time.
No.
Time is there.
No.
No time. Kindly see in the FIR your time mentioned from which period to which period. In FIR. No mention. Where is the FIR?
Page 5 of my application. No, page 5.
Where is the page 5 is the
Page 37.
page?
My application. Page 37.
Page 37. 37 is the complaint. Where is the FIR?
Medical or
First information report, general diary, occurrence.
Page 35.
Yes, kindly come to that. Occurrence offense since 4 months after the marriage.
It started.
So where is in the FIR, where is that 27 March, 27/11?
Second page, my lord.
I am asking with regard to your information, what your police is doing? In your complaint, specific date has been mentioned. So occurrence of day. Where is that? Since 4 months after the marriage, that is the complaint. It is a specific complaint that 27th of November 2023, the incident was occurred. Though the marriage was solemnized 4 months before. Where is that? If FIR started 13 March. And general diary reference, okay, no, 1625 hours. Occurrence of the offense, day, since 4 months. Nothing, 27/11, nothing. Yes, so what is the complaint? Consume poison. Consume poison. Where is the report, medical report?
My lord, I have for the state, my lord, medical report, we have given to requisitions for the medical report, but that has could not be collected.
Charge sheet filed.
Charge sheet has been.
Then. And you are not paid for, in the charge sheet, you are not paid for supplementary. You are not asked that you have not got the medical report, you filed supplementary charge sheet. There is nothing. Who is the Raju Shah? Why the warrant has been issued against you?
At the time of charge sheet, thereafter he obtained bail from this honorable.
When the charge sheet was filed?
The charge sheet has been filed on
April 2024. Within a month. But there is no report. Where is that mentioned? There is nothing mentioned. No doctor. Doctor what? What is the evidence of the Dr. J. Helder? CS4? Why the J. Helder is there? What is in the CD? We got to go to the doctor.
This is the CDs, what to say, my lord, didn't like to.
not even another independent witness.
What you either you tell your
They have
police.
collected some papers, the invoice and all regarding the dowry and all, my lord. Those things are there.
Dowry
In
is there.
support of the FIR, my lord.
What's
No,
the where is
there was
what is the Caesar?
my lord, it's in the pages, my lord.
Surrender sleep. Recall sleep.
Lord, as per the charge sheet, my lord, the property of the Caesar nil. Nothing has been.
Nothing. That's I'm feeling. There's nothing.
Investigation খুব বাজে হয়েছে।
Charge sheet there is
নানাজি
nothing.
দিয়ে দে এটা, নানাজি দিয়ে দে।
এখনো নারাজি দেবো কিন্তু ওই পক্ষে।
What the police is doing in West Bengal? Yes, anything? Tell me.
Well, opposing the quashing application, my lord, there are some disputed question of.
What? Tell me what is to be what is to be looked into during the trial. Tell me this code.
My lord.
That is the only
My-
482.
My lord, number one, there is an explanation for the delay.
Delay, leave aside. I am not going to the delay.
My lord.
Leave aside the delay.
My lord, secondly, my contention is, my lord, there is a.
When the incident was occurred, 11 or October?
Yes, my lord.
11 or October? November or October?
11, my lord.
11.
27,
Now,
sir.
if you are relying upon the FIR 11,
Yes.
now kindly come to your two independent witness, the witness. 161. Got it?
My lord.
So, how will you explain that?
At
Your
this
IO,
stage, I cannot
it is not the, it is your IO recorded. Handwriting your IO.
My lord.
So, and की बोलছি उसमें क्या बोला कुछ नहीं बोला what is stated both this only they heard and they went
Yes, my lord.
and the victim is stated whatever it is and victim stated the poisoning. Where is the poisoning evidence? Sent to the medical report is there. That's why see.
Medical report has not been received as per the submission of the state.
That's all.
My lord, this, somebody is traveling by train, these are disputed
I
question
am
of
not
facts.
I am telling. I am not relying upon this traveling document. Since beginning from what I am taking I am not taking the additional document while considering the 48. I am considering the document which you relied upon. Your case depends faulted with regard to the date of occurrence. First thing. Second thing, the two witnesses, the brother and mother, they have not stated anything, only they heard that she has been assaulted. Correct. Wife has stated that has not been corroborated by the medical because it is specifically the poisoning and went to the hospital and FIR was lodged. There is no medical report. Third, the FIR 2710, charged in the witness 2711. Fourth, there is no injury report. So how you can prove? The court has to see what is the document that it can be tested in the trial, during trial. You satisfied me. No problem. Satisfied this court, I am dismissing herein now. It is not that all the 482 has been allowed by this court.
But my lord wants to hear it from my mouth. That is the difficulty. My lord wants to hear something from
Not-
my mouth.
I don't want that
is
you
the
should admit.
difficulty.
I don't want the court.
That is the greatest
In-
difficulty I am
in-
facing right now.
Huh?
That is the greatest difficulty I am facing right now. We are online, my lord.
Hearing
Kindly record my strong objections. I tried my best to say
suffering
my
for the petitioner, Swenson suffering for the state, and Swenson suffering for the de facto complainant. Hearing concluded CAB. I don't know further here.
দিয়ে দে এই এই যে নামটা সবাই তো পেন
আমি লাস্ট আমার একটা ছেলে দেখছিলাম বাবার সাথে দেখলাম আমি পাকিস্তানের বয়স্ক লোকটা ছিল আর একটা দুটা না ওটা করে ওইটা হ্যাঁ করে আরেকটা ছিল আমার বিল আউটছে আরে তখন দুটো একটা করে দেখতেই গভর্নমেন্ট আমি ভেলদিস দেখি বড় দেখলেও বড় বলে না বড় সিরিয়ালটা দেখি না আমি এখন দেখতে পাচ্ছি
কি বিচ্ছিরি দিলে তোমার কম্পিউটার দিল মানে এত ওটাকে ফেলে দিয়েছে ঠিক আছে মানে প্রথমে গল্প মিল আমি যদি এখন যদি জাজমেন্টের মাইন্ডে সামনে তিন নম্বর ওটা কিলো মালা পর্যন্ত লিখে দিল না আপনি সবার প্রথমটা তো লাগবে এগুলো তো করে দেব বাবু আমি ওরা ক্যারেক্টার ওখানে যা আছে না হ্যাঁ আসলে পাঠগুলো করেছে শক্তিমান না ওটা ছিল না হ্যাঁ ইস লাস্টে এটা দেখে না সিরিয়াল কিন্তু ভালো লাগে মানে এই 15 মিনিট পরে পাঠটা দেখে পরে পাঠটা দেখে এটা খুব ভালো লাগে কাজে তোমাকে কাম করতে হবে শীতকালে তো ঠান্ডা জায়গায় তো যায় না ওই হরমোনগুলো দাও ওতে বন্ধুরা যেটা ছিল বন্ধুরা ছাড়া একটা পর একটা ছাড়া ভোর 5টা হলে বেরিয়ে গেছে দেখতে যাইতে হবে তাহলে ঘুমিয়ে ঘুমিয়ে বসে এটা মেনে দেব আমি বলে তাই না দেখে বললাম ওইটা না আসে রেডিও ভালো করে একটা করেছি এটা মাগাটা বডি দিয়ে যাচ্ছে বাকি আছে ওরা ওরা ভালো ভালো ওই কি নেই ভাই এবারে কাটতে ওই 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 মুহূর্তে তোমার গার্লফ্রেন্ড না হয়ে আমার এক্স ছিল তখন দুঃখ হচ্ছে আরে ইচ্ছে আমি ভাবছি না এই করতে এটা ভালো লাগে ইন্দ্রিয়া বাংলা এই জাত সুন্দর এই মানসিক না ইন্দ্রিয়া
কি জন্য 500 হলো? আচ্ছা 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 ঠিক আছে।
Sure, this has to go at.
Yes, sir. না আজকে আসেনি ওই একদিন করে আসে আবার একদিন আসে ছিঁড়ে যায় ছিঁড়ে যায় রেস্টুরেন্ট সবাই ছুটিতে আসছে আলুটা কাটবো কি রোদবাবু কি আছে কেমন আছিস ঠিক আছে তো বাহ কি আছে ম্যাটার ভাই সিয়ারা
একটা রেস্টোরেশন
রেস্টোরেশন দাঁড়ালেই দিয়ে দরজাটা বন্ধ খুলে রাখে কেন গানটা করি সাহেব আসতে দেরি আছে আজকে পুরো গানের মোডে আছি গলাটা আজকে খুব ভালো আছে ভম ভম করছে এই শুনতে পারলে মুশকিল কিসের বাতাসি বাতাসিয়া লুক যেখানে তার স্টেশন ম্যানেজার ফোন নাম্বার কি করবে কিছু ফেলে এসছেন ও আচ্ছা আচ্ছা ঠিক আছে দার্জিলিং না দেখি সিআই কে ফোন করি ব্যবসা করবেন হ্যাঁ এগুলো না ফোনে মানে আছো না সিএম ডিউটিতে ঠিক আছে সিআই সাহেব মিটিং এ আছেন পরে করছেন করে দেবো আপনাকে আমি পারি করে দেবো মুকুলদা শরীরটা ভালো মুকুলদা আপনার বাবা এখানে ছিলেন পোস্টেড মামা স্টেশন ম্যানেজার ছিলেন ও তা আপনি যেতে হবে ও আচ্ছা কবে যাবেন গেলে শনিবার ঠিক আছে নাম্বারটা জোগাড় করে দেবো আপনাকে আপনার নাম্বারটা দেখুন শনিবারকে ঘুরতে চলে দার্জিলিং এ যাবো ভাবছি বিকালে চলে যাবো মেয়েকে আর বউকে নিয়ে গ্যারেজ করে দিয়ে রোববার পাসপোর্টটা পকেটে নিবো ডলার কার্ড নেবো এরা বাড়িতে যে টাকা ঢোকায় না টাকা দেবে টিকিট হয়ে গেছে টিকিট হয়ে গেছে হ্যাঁ থ্যাংক ইউ স্টেশন মাস্টার বাহ নাম্বারটা খুব সুন্দর তো 86979794 নাম্বার সবচেয়ে মনে রাখা আমার নাম্বার আমার নাম্বার হচ্ছে সব 11255 11155 সিগারেট নাম্বারটা বলুন 98320 11555 97330 11555 99320 11555 কত টেলিকম কোম্পানি ছিল একটা ছাড়া সব এখন তো বিএসএনএল তবে বিএসএনএল সরকারি ওটা ফাইন ওটা প্যানেলে বাকি সব যত বেসরকারি সব প্রচুর কাল মালদার ওখানে রিলায়েন্স ইনফ্রাস্ট্রাকচার রিলায়েন্স টেলিকম রিলায়েন্স ইন্ডাস্ট্রি রিলায়েন্স পেট্রোলিয়াম চামড়ির সাথে মিটিং করছি রাস্তার সময় রাস্তা বন্ধ হয়ে গেছে আমার ছেলে ছিল রাস্তা তারা ভুলবে না যতটা কোল্ড ড্রিঙ্কস বোঝে না যতটা খেতে খেতে পুরোটা খেতে পারবি না দুই চারটে খেলে এমনি ঘুমায় পড়বে খুব ঘুমাচ্ছে জায়গাটা হচ্ছে দাদা আমি তো খাই না তুই জায়গায় থাক আমরা 3টার সময় রাস্তা দিচ্ছি চল চারটার সময় এসে বাড়ি মানে তুমি কোন বর্ষাকালে পাহাড়ে যে বৃষ্টি ওটা হয় না মানে এই বড় বড় সাইজ মানে তুই গাড়ি চালাবি ছেলেটা এসে বলবে
আমি ইচ্ছা করে ঘুরে আসছি কিচ্ছু কিছু জায়গায় না আমি ওই দিকে আগে গেলাম ছিলাম পাঙ্কাবাড়ি রাস্তায় তারপরে পাঙ্কাবাড়ি থেকে আমার উঠে আসছি ওই দিকে নেমে পাঙ্কাবাড়ি নাম ওই রাস্তাটা শ্রীগুলো অন্যরকম গেলাম তাই কি হবে
চুপ করে যাবো না বললাম নাম্বার তো দেখবো না তাই ভিডিও ফটোগ্রাফি করেনি জিএসটি পাওয়ারে বলে জিএসটি দাঁড়িয়েছে না একদম ওজনে পারবো মাটির জন্য
আমার দিকে একটু
Yes.
Item number 71. For the petitioner to view the affidavit of service.
But this is a case related with NI Act.
Hmm.
If your lordship kindly take the order impugned. Kindly see.
Order dated 20 July.
Order dated 20th July.
Yes.
Kindly see. Without assigning any reason, relying to judgment of the Honorable Supreme Court, which was also not been rightly appreciated. When the trial court was
You are
placed to
appearing for?
accused, petitioner. They are accused, he has the petition.
Yes.
Now, my lord, can you see the judgment which was denied by the learned trial court? Relevant portion I have marked out. Paragraph number 24. While deciding the prayer made by the under section 143A, the court must record the brief reasons indicating the consideration of all relevant factors. This judgment was denied by the learned trial court. But he failed. I'm very sorry to say, the learned trial court failed to appreciate the mandate of the judgment. And so far the section is concerned, my lord.
Yes.
No, my lord, so far the legal mandate is concerned. 143 is a discretionary matter, not mandatory. Now, my lord, I'm very sorry to say, for the learned trial court.
Have you obtained the Pawan Basin matter judgment?
My lord,
the other judgment, Pawan Basin?
That was passed in case of 251. If I plead not guilty, that order can be passed. That order not with me, my lord.
Yes.
Can be passed. This is the mother judgment of the NI Act 143A. Where Honorable Supreme Court was pleased to observe that this is a discretionary and not mandatory, and for the relevant factors to be considered, and the reason order should be passed. Without assigning any reason, the order was passed.
Yes.
Depend upon the trial court.
Huh?
Depend on the trial court. So for the whether the conduct and the activity.
No. Kindly satisfied me. What are the consideration taken by the Honorable Magistrate? What is the reason taken by the consideration? Then
146 policy, you said.
there is no reason.
Yes.
So what can be done? You are for the accused,
No,
petitioner, complainant,
I am for the
state. Who is for the other side?
even if service has been affected, but they did not turn up.
I want the state. They are challenging the order passed by the learned jail part to Jalpaiguri. So they made a part to state.
The criminal division have made a part.
Obviously.
It is a necessary part.
Who is your typist? On the last occasion, I also asked you.
There is an old matter, but since then.
What old matter? This is a 25 matter.
No, 24 matter.
So then?
Since your lordship was pleased to ask me, I have already asked him to make the.
How the office is accepting these applications?
No justification I have taken. Well, I am very extremely sorry for that my unintentional mistake, my lord.
Not unintentional. See, what proceeding? You have to follow the.
My lord, since when your lordship was pleased to ask me, I have already made that correction.
Filing the petition before the High Court, prescribed format has been given in the notification. You have to follow that.
My lord.
Devnath Sanyal, son of so. Who is the opposite party?
Opposite party, sir, Debato Sanyal, my lord.
Debato Sanyal. But what the address you mentioned? Where is the complaint? You have not enclosed the complaint. You have enclosed the complaint, yes.
Complaint I have enclosed. Page number 10, my lord.
Page number 10.
10.
8 or 10?
10, my lord.
10. Item delivered.
Item delivered, but it did not appear.
No. Redirected to the Bhakti Nagar for so insufficient address. Item delivered to addressee.
That was
Item received 22nd, bagged, dispatch, received, dispatch. Out of delivery. It was written to you.
no, my lord. My lord, if your lordship kindly give me the that was what I can show. Item delivered to the addressee, my lord.
But correct, but in the meantime, middle you say
In the midway, that was returned to the Bhakti Nagar SO. Subsequently, that has been again dispatched. And again, ultimately, on 24th April 2025, item delivered to the addressee, my lord.
So offering for the petitioner. So offering for the estate. None appears on behalf of the OP number 1 in spite of service of notice. The petitioner has filed the affidavit of service. Let the same be kept with the record. The petitioner has challenged the order passed by the learned judicial magistrate, Third Court, Jalpaiguri. क्या बोला? Dated 20 July 2024, wherein the London magistrate has allowed the application filed by the complainant / opposite party number 1 herein under section 143 capital A of the Negotiable Instrument Act, directing the petitioner to make payment of being the 10% amount of the check amount of rupees 17,60,000 within 60 days from the date of the order. That is, the petitioner has to pay an amount of 1,76,000. The counsel for the petitioner has filed this revisional application specifically on 2 grounds. That is, the order passed by the London magistrate is without any reason, and the judgment relied by the London magistrate is not London magistrate, has not considered the fact the judgment relied by the London magistrate, the London magistrate has not considered the total totality of the judgment passed by the Honorable Supreme Court in the case of Rakesh Ranjan Srivastava versus of State of Jharkhand and another reported in 2024, volume 4, SCC 419. List. London Council for the State submits that the London magistrate has passed the order in its discretion, and there is no illegality in the said order. But the London Council for the petitioners and the state. This court find that the complainant / opposite party number 1 herein had filed an application before the London magistrate under section 143 capital A of the NI Act. Full stop. The London magistrate only citing the judgment of Pawan Basin versus State of UP and another, and Rakesh Ranjan Srivastava Supra directed the petitioner to pay the 10% of the total check amount of rupees 17,60,000. Then counsel for the petitioner submits that though the learned magistrate has passed the judgment referring the above cited case, but learned magistrate has not taken into consideration the judgment in its totality. The Honorable Supreme Court, in the judgment of Rakesh Ranjan Srivastava Sutra, held that record करो paragraph 23 से 27.3.5. In this case, in the present case, this court perused the impugn order and find that the learned magistrate has passed the order by allowing the application under section 143 capital A, but has not assigned any reason under what circumstances the petitioner is required to pay the 10% of the check amount. In view of the above, this court find that the impugn order dated 20 July 2024 passed by the learned magistrate is without any reason and has not taken into consideration the totality of the judgment passed by the Honorable Supreme Court, wherein the Honorable Supreme Court has categorically held that the for grant of interim compensation, the court has to apply its mind to the quantum of interim compensation to be granted, and the court will have also to be consider various factors such as the nature of transactions, relationships, if any, between the petitioner and between the complainant and the accused, and the paying capacity of the accused. The Honorable Supreme Court has further held that if the defense of the accused is found to be prima facie a plausible defense, the court may exercise discretion in refusing to grant interim compensation. The Honorable Supreme Court has further held that exercise of power subsection 1 of section 143 capital A is a discretionary. The provisions of the discretionary and not meant if discretionary, as the word may used in the provisions cannot be construed as shall. Considering the above, this could find that the London magistrate and the impugn order passed by the London magistrate is without any reason and without considering the parameters suggested by the Honorable Supreme Court in the case of Rakesh Ranjan Srivastava Sutra. In view of the above, the impugn order dated 20th July 2024 passed by the Learned Judicial Magistrate Third Court Jalpaiguri in CR case number 215 of 2023 is set aside and passed.
So that they cannot take any unnecessary adjournment. Only to track,
Full
they will
stop.
want to track the proceeding, that's why the
Full stop.
amount paid then.
No, I cannot.
None of the parties may be grateful.
Item number 72.
Lordship, at the inception, Lordship, I prefer apology for could not bring the case diary. Due to technical glitches, the mail could not be delivered.
Okay, next circuit. And when the court was already 5 judgment is heavy. Quashing. Court has to apply its mind. Already 3 matters are fixed tomorrow. Come, next circuit. Next. There is no CD, man.
No. Lordship,
Have you filed the civil suit? Got the injunction?
Supposing that file the FIR, they have also filed.
What is the case against you?
Forging for the purpose of cheating, use of false documents.
Yes, for document, how the 482 will gone into? CFS, handwriting expert is there, report is there.
Lordship, there is allegation in the FIR that উক্ত ব্যক্তিরা জমির নকল জাল কাগজপত্র দেখিয়ে আমাকে জমিতে দিতে বাধা দেয়।
I will show my lord, there is a permanent injunction direction against the de facto complainant, the person from whom he has purchased the property. After the permanent injunction was given, my lord, she sold the property to the de facto complainant, and thereafter the de facto complainant has filed this FIR, my lord, and stating that I am the one who is trying to dispose him from the property, whereas there is a permanent injunction against them not to enter the property, my lord.
Violation?
Violation case has been done, my lord, in the lower court, my lord.
13 and 2A.
Yes, sir. Have been done.
Then what has happened?
We have also taken a direction to speed up the civil case, my lord, but the civil court is going on giving time again and again to them, my lord. That is the position of law, my lord.
What can be done?
Yes, my lord, that's why I'm asking for my lord, kindly, my lord. I one matter.
Not today.
Nothing. Yes, Lordship.
Next.
Item number 73.
Gambling Act, my lord. I have been, my lord, entangled.
4,000 rupees the board amount.
Board amount 4,000.
4,900.
And what is the recovery from pocket amount?
Nothing, my lord.
Nothing. There's no pocket amount. So without pocket amount, only board amount, how the this gambling can be done?
My lord,
the players
actually, those who are carrying it in their pocket ran away. That is why no pocket amount. My lord, actually, there was a seizure of an arm, this gambling board, gambling sheet, and the one
98 pieces of playing cards.
playing cards.
Iron made, imprisoned one
Improvised,
shooter.
yes, not from him, my lord, but
From whom?
from
Improvised one shooter having total length of 9 inches. What you are
From
doing with
other-
this? What you
I
doing?
was even not in the place of occurrence, my lord. On the strength of my lord, the confessional statement, my lord, my name has been, my lord, entangled. There
Lie
are almost, my
ammunition.
lord, 20.
That to
22, my
3.303.
lord.
yes, my lord. It is not from him,
From whom it was seized?
my lord. Let me
Where is the seizure?
see here it is. It is from Anej Mia. Here is the seizure list.
Anemia. Yes. So, this arms act is in arms act is there
Yes,
against whom?
against Chashita.
Which section? Arms act? Section 25 1B
Yes, my lord.
and 27
25-1.
Only 25-1.
27 30, no, charge sheet is
No,
not
no,
there.
no.
Against all, my lord,
Against all.
against all.
Yes. What is your name?
My lord, my name is Hafizul Khandokar.
Hafizul Khandokar Mia. He is the
Serial
FIR
number
name.
7, my lord, in the charge
He
sheet.
is the FIR number name.
Yes,
Your
Yes,
name
my lord,
is-
FIR has a suo motu FIR has been made, my lord.
yes, his name is here.
In FIR, my lord, my name is on serial number 40.
Serial number
40.
14.
Yes, my lord.
Yes, yes. Hafizul Mia. 14. There are 24 accused persons named in the same FIR.
When the incident was occurred?
My lord, incident occurred, my lord, on 24th of October 2019.
During Deepavali.
Yes.
Abbas Mia, you are Abbas Mia.
No, my lord, I am
Official.
Khandokar, LIC Mia.
14th.
No, 14 is Abbas Mia in the FIR.
Matlab 13 man, 13. Big, 13.
13 official. Where is the, what is the evidence? He was arrested at the spot. When he was arrested. Where is the arrest memo? And charge sheet also does not disclose what has happened, only FIR and name of the accused persons.
Well, the MOE I find.
How the trial court are framing charges without disclosing all the things in the charge sheet?
তো নামই নেই।
Nothing. Charge sheet, nothing is stated. Only his name has come and his section has come. Investigating officer consulted with the senior officer and filed the charge sheet. Name is there, but what time, where he was arrested? From where he was arrested?
The list of arrest warrant.
And where is the evidence that he was involved in the playing gambling?
Well, I do not find that.
Because the police has raided. If the police has raided, police might have been identified, he fled away.
Yes,
Where is that evidence?
There are 161 statements well. একটু পড়ুন না। একটু পড়ে দাও। My lord, I'm একটু পড়ে দাও।
Statement of on SI Raju Roy.
হ্যাঁ
আমি SI Raju Roy,
হ্যাঁ
ইংরাজি 24/10/19 তারিখ আমি SI তাপস দাসের সঙ্গে অন্যান্য অফিসার ফোর্স নিয়ে প্রায় 9:45 নাগাদ রানীনগর অ্যাপার্টমেন্টে যাই। তাপস দাস এর কাছে খবর ছিল ওখানে বাবু বাপাই নামে এক ব্যক্তির বাড়িতে জুয়া বসেছে। এরপর তাপস দাস দুজন স্থানীয়
কি নাম? বাপু? বাবু?
বাবু এবং বাপাই।
Babu and Bapai, they are the accused.
নো
No, no, their body,
হ্যাঁ ইয়ে বাড়ি
in their house, the gambling is going on.
ব্যক্তির বাড়িতে জুয়া আসর বসেছে।
Correct.
এরপর তাপস দাস দুজন স্থানীয় লোককে সাক্ষী হিসাবে ডাকে। এরপর আমরা বাবলু ব্যাপারী, সরি নট বাবলু ব্যাপারীর বাড়িতে ঘেরাও করতে থাকলে 20-25 জন ব্যক্তি আমাদের দেখে দৌড়ে পালাতে থাকে। আমরা তাদের মধ্যে একজনকে ধরে ফেলি। এরপর সাক্ষী দুজন সহ আমরা ওই বাড়িতে ঢুকলে একটি ঘরে 4990 টাকা ও 98টি প্লেইং কার্ড উদ্ধার হয়। এরপর ধৃত ব্যক্তিকে জিজ্ঞাসাবাদ করা হয়। তার নাম জানায় আনেজ মিয়া, বাড়ি ঝুড়িপাড়া নাকি বুড়িপাড়া। সে স্বীকার করে সে এবং তার সাথে আরো অনেক ছিল। এরপর ধৃত ব্যক্তিকে সার্চ করলে তার পেছনে কোমর থেকে থাকা একটি ওয়ান রাউন্ড গুলি সমেত উদ্ধার হয়। ওয়ান শাটার এন্ড ওয়ান অ্যামুনিশন এরপর তাকে
From whom it was seized?
Anuj Mia.
Anuj Mia.
Anuj
Yes, this is a list.
He was there.
Yes, he was arrested.
তাকে গানের লাইসেন্সের কথা জিজ্ঞেস করলে সে বলে
Next.
That's all. And another any witness?
Yes, two others.
Tapas Das, SI Tapas Das,
সেই
he is the complainant.
শ্যামল বিশ্বাস
Shamul,
নির্মল মাল
How this petitioner have been identified?
it was Caesar list. Hafizul, isn't it?
Hafizul Mia. Hafizul Mia.
Who accused you of this?
ওই 20-25 জন পালাতে থাকে
That's all. So how he has been identified? How he has been arrested?
Arrested or surrender?
Surrender.
সেটা বল, your list of arrested, finding his name.
So he has been surrendered. So what is the evidence? Because his name was there, he surrendered. Where is the evidence?
Nothing legit.
How the charge sheet is filed? Hafizul. Hafizul. J-U-L. Jul. Not.
এখানে বলছে সে চৈত্র বর্মন, মফিদুল হক, রাজকুমার সেন, নির্মল সেন এবং আরো অনেকে।
Hafizul নাই, আমি দেখছি। Hafizulর নাম নেই। Xerox ticket ফল।
এখানে পুলিশ কাজ করে Hafizul not there.
His name is also not appearing in the 170 তো নাম আছে, তার সাথে তো নাম আছে। সিভিকে কিছুই মাঝখানে পাতাগুলা দেয় না, আমি কি করি? আমরা তো
যেটা ছিল না এত টাকা উদ্ধার হলো তার পিছনের পেজটা নাই, সব পিছনের পেজে নাম আছে। এটা এটা কি এটা নিয়ে এটা না এটা নিয়ে
একটা জেরক্স সিভির নমুনা।
What is the evidence of the Nilmar Sarkar?
নির্মল সরকার মানে?
Nilmar Sarkar and Umapaddo Shah.
Yes.
Nirmal Sarkar
নির্মল সেটা ইজ দেয়ার
and Umapaddo Shah. There are two independent witnesses.
জিজ্ঞাসায় বলছি আমি উক্ত ঠিকানায় একজন স্থায়ী বাসিন্দা। আজ সকাল 9:30টার দিকে প্রায় পুলিশের লোকজন আমাদের এখানে আসে এবং আমাকে ও উমাপদ শাহকে বলে যে এখানে একজনের বাড়িতে অবৈধভাবে জুয়ার আসর বসেছে এবং তাদের ধরা হবে আর সাক্ষী হতে বলে। আমরাও রাজি হই। তারপর পুলিশের লোকজনের সাথে বাবলু ব্যাপারীর বাড়িতে যায়। তখন পুলিশের লোকজন দেখা মাত্র ওই বাড়ির থেকে 19-20 জন লোক পুলিশ পালিয়ে যায়, কিন্তু একজন ব্যক্তি নাম আনেজা মিয়া ধরা পড়ে। তারপর পুলিশের সঙ্গে আমরা ওই বাড়িতে যাই। আনেজা মিয়া দেখায় যে তারা যে ঘরে জুয়া খেলছে ওই ঘরে ঢুকলে 94টি তাস ও 49,090 টাকা উদ্ধার হয়।
এরপর আনাজা মিয়াকে জিজ্ঞাসাবাদ করলে সে বলে যে সুভাষ সেন, চৈত সেন, মজিদুল হক, সুধীর বর্মন এবং আরো অনেকে মিলে তাদের অবৈধ লাভ লোকসানের জন্য জুয়া খেলে। আনেজে মিয়া সেই জুয়ার আসরে আয়োজন করে। আনেজাকে পুলিশ সার্চ করলে একটি ওয়ান শাটার বন্দুক, 1 রাউন্ড গুলি সহ উদ্ধার হয়। পুলিশ ওই তাস, বন্দুক ও টাকাগুলি সিজ করে। সিজার লিস্টে আমি সাক্ষী হিসেবে সই করি। ঘটনার সময় বাবলু বাড়িতে ছিল না। আনিজাকে লোকজন নিয়ে এসে মাঝে মাঝে লোকজন নিয়ে এসে বাবলুর বাড়িতে জুয়া বসাতো বলে জানি।
Yes. Sense opening for the petitioner, sense opening for the state. The petitioner has filed the present application for praying for quashing of the proceeding initiated by the police, by the Nahata Police Station case number 456/2019, dated 24th October 2019, under section 3/4 of the West Bengal Gambling and Prize Competition Act, read with section 25 within bracket 1 dash capital B bracket close of Arms Act and the charge sheet number 5 of 2024, dated 17th January 2024, pending before the learned Additional Chief Judicial Magistrate 1, Dinahata, Kuch Bihar, being GR case number 1, being GR case number 471 of 2019. Counsel for the petitioner submits that on the basis of the complaint of S.I. Tapas Das, the police of P.S. Dinahata had registered the above case, in which the name of the petitioner is also included. Though the police has initiated said case, after the initiation of the said case, police has completed the investigation and filed charge sheet. In the charge sheet also, the petitioner has been entangled. Counsel for the petitioner submitted that though the name of the petitioner is appearing in the FIR and the charge sheet, but there is no evidence on record to prove that the petitioner was present at the place of occurrence or the petition has played any role in the alleged gambling. Counsel for the petitioner submitted that as per the case of the prosecution, the police of P.S. Dinahata received an information in regard to the gambling in the house of Bapi, in the house of one Bablu Bapari, and accordingly the police has alleged to have conducted raid, but the police have only arrested one Anejmia. Arrested only Anjemi, A-N-J-E-Y, Anjemia, from the place of occurrence, and none of the place of occurrence. It is the case of the petition prosecution that the alleged accused who was arrested and the accused who was arrested has stated the name of the petitioner and the other persons, and according the police has initiated the case. Counsel for the petitioner submitted that in the charge sheet, the investigating officer has cited altogether 16 witnesses, but none of the witnesses have stated in their statement in their statement with regard to the involvement of the present petitioner. Counsel for the petitioner submitted, neither the petitioner was present, nor anything was seized from the petitioner, or there is no evidence on record with regard to the role played by the petitioner in the alleged offense. He submitted that only on the basis of the name provided by the co-accused, the police has registered an FIR, including the name of the petitioner and also included the name of the petitioner in the charge sheet. There is no material on record to prove that the petitioner is involved in the present case. Accordingly, he prayed for quashing of the proceeding initiated against the petitioner. Per contra, learned counsel for the state submit that as per the information received by the police, the police has raided the house of one Bapi and Bablu Bepari. But in the meantime, the persons who were playing gambling in the said house, from all the persons have fled away from the place of occurrence, and only one person was arrested, that is namely Anjay Mia, and he has confessed that the persons were playing gambling in the said house, and he has disclosed the name of the petitioner. Counsel for the state submitted that as the petitioner fled away from the place of occurrence, and as such the police could not arrest him, but subsequently the petitioner himself has surrendered before the learned court wherein he was granted bail, which proves that the petitioner, by surrendering himself before the court, has admitted that he is involved in the matter. Counsel for the state submitted that the raiding persons who accompanied the complainant at the time of raid have stated that the petitioner was involved, but he has fled away from the place of occurrence. The learned counsel for the state further submitted the police has completed the charge sheet, completed the investigation, submitted the charge sheet, finding prima facie case against the petitioner, and as such, it is not a fit case to pass the proceeding against the petitioner. But the learned counsel for the respective parties peruse the materials on record. This could find that as per the information received by the police authority, the police have conducted raid in the house of Bablu Bepari, but at the time only the police has arrested one person, and nobody was one person, and the arrested person has disclosed the name to the police. But in the 161 statement recorded by the investigating officer during the investigation, who have been cited in this present case as witness to the case, in none of the statements, any of the witness have stated the name of the petitioner to establish that the petitioner was present at the place of occurrence and was playing gambling in the house of the Bablu Bepari. Though this court has also gone through the statement of each and every witnesses, but none of the witnesses has stated the name of the petitioner. In the charge sheet, this court has considered the charge sheet. In the charge sheet, the investigating officers only recorded with regard to the contents of the FIR and stated that on completion of the charge sheet, he has submitted completion of investigation has submitted charge sheet. In the charge sheet also, the investigating officer has not stated with regard to what is the allegation against the petitioner and who has identified the petitioner and how the petitioner is involved in the matter. The police has also seized seized rupees 4,990 from the alleged place of occurrence. But that is also not seized from the hands of the petitioner. It is found that at the time of raiding the house of Bablu Bepari, on the information received by the police, the police has raided the said alleged place, of occurrence, along with the two independent witnesses, namely Nirmal Sarkar and Uma Paddo Shah. The investigating officer during the investigation has recorded the statement of these two independent witnesses also. This court has also gone through the statement of these two independent witnesses. These two independent witnesses stated that they accompanied the police, and when they reached the place of occurrence, that is the house of the Bablu Bepari, several persons have fled away. And these two persons have stated the name of some of the person, but these two persons who were the who accompanied the police alleged to have been accompanied with the police person have not stated the name of the petitioner or identified the petitioner Police stop. Okay. Considering the police stop. So, while exercising the jurisdiction under section 482 of the Code of Criminal Procedure, this court not ordinarily embark upon the inquiry whether the evidence in question reliable or not, or whether on a reasonable apprehension of the acquisition would not be is available or not. But in the present case, this court has considered the FIR, statement of the witnesses recorded under section 161 of the CRPC, as well as the seizure memo. Considering the all facts, this court find that only the name of the petitioner is appearing in the FIR and the charge sheet, but it is not. But from none of the record, it is found that how the name of the petitioner is appearing. Only from the statement of the it is the case of the prosecution that the petitioner was arrested, that the arrested accused person has given the name of the petitioner, but the petitioner has not been identified by any of the person, or none of the witnesses, or in their 161 stated that the petitioner has been identified while he was fleeing away from the place of occurrence. Considering the above, this court find that there is no evidence on record against the petitioner for the offense under section to establish the case against the petitioner for the offense under section 3/4 of the West Bengal Gambling and Prize Competition Act. Police. It is also police. As regard the Arms Act, as regard section 25 within bracket 1B of the Arms Act, the said section is not applicable to the present petitioner, as the said arms alleged to have been seized by another accused person, namely Anej Mia. Considering the above, this court find that this is the fifth case wherein this court can invoke the provisions of section 482 of the CRPC. Accordingly, proceedings of the Nahata Police Station case number 456 of 2019, dated 24/10/2019, under section 3/4 of the West Bengal Gambling and Prize Competition Act, along with the charge sheet number 5 of 2024 dated 7th January 2024 pending before the Learned Additional Chief Judicial Magistrate -1 Dinahata Kuch Bihar being GR case number 417 of 2019 is set aside only with regard to the petitioner hearing. The petitioner is discharged from the bail bond. CRR number 76 allowed.
Number 74. Lord, for the petitioner, Lord,
Opposite party.
that matter, Lord, where interim initial maintenance was 4,000, enhanced to 8,000. And Lord, your lordship had directed, Lord, the wife to come for this court. Lord, my client is also present. My client is also present. Lord, my client was proposing an amicable settlement, Lord, by paying a permanent alimony.
Correct.
Yes.
How much you will pay?
Lord, that we have to.
Sit together.
My lord, may I, my lord?
Your client has filed a matrimonial suit.
My lord, the client is here, my lord. On the last occasion, your lordship had desired to settle the amicable. So, my lord, I insist upon that you take the.
What's he telling?
But my lord, she has softly told me that my lord, their marriage has been solemnized in the year of 2025, 2009. Thereafter, from 2012, their marriage has been broken up. My lord, at that time, she was physical and mental condition to marry him. Now, my lord, the present situation is that my lord, she along with his 66-year-old father, again reside in Kolkata, that is Atala Shamukala police station. But it is a small village. He said to me, my lord, that if at present, my lord, I am getting the tag of divorce, or it is very difficult for me to, my lord, to reside in said village with my old.
Correct.
parents.
That's why. So if it's a permanent alimony, what is your expectation?
Or he don't want to take the father.
So you will only maintenance and divorce.
No, not that.
All right.
You don't. Who has filed the matrimonial suit?
She has filed the matrimonial
She has filed the matrimonial.
for maintenance.
For me,
What maintenance? Maintenance. You don't want to go for the divorce, not permanent alimony.
But 14 years, the marriage has irretrievably broken down, my lord.
So nobody has filed a
I have
matrimonial.
filed a matrimonial
You filed
suit.
a
Yes, that was dismissed, my lord, and appeal is pending before the.
Dismiss on merit.
On merit, my
Dismissed
lord.
on merit.
On merit dismissed.
Lord, an appeal is put, still pending. Now, my lord, these litigations will go on for years and years. My lord, if this is settled amicably, and since my client is also insisting. So there is no harm in doing this. The reasons given by my learned friend, my lord, is vexatious, my lord, that if she gets the tag of divorcee, my lord, she will be facing reprimand in the village.
That is the ladies look upon their own choice.
My lord, may record my client's instruction that, my lord, he is willing to settle the matter by paying a permanent alimony one
But
time.
she's not. So this court by in this divisional jurisdiction, how the court can pass an order? That's why I wanted if she will settle, then I could have been sent the matter to the mediation or the matter settled here, the court can dispose of hearing now, but she is not.
My lord, if on the level of the councils, my lord, if we try, because I am trying my level best. My lord, if
My lord, I am
client-
also tried my level. Last occasion, I may insist upon the client. My lord, she is here. If your lordship has kindly asked, my lord, she don't want to permanent.
There is no issue.
No.
No issue.
No issue.
No issue. She is staying separately, I am staying separately, 14 years, my lord. What is the purpose of keeping this rank for no child, nothing, my lord? Let it be sent to mediation at least once, my lord. Let us try our level if we can do something.
यस आप क्या चाहती है? हिंदी जानती हैं? आप हिंदी जानती हैं?
हिंदी बोलो
ना.
কি চাও তুমি বলো
What do you want? Monthly maintenance. Settle it once for all.
একবারে সেটেল করতে চান
Okay.
I insist upon my lord.
Okay.
My lord,
good.
what will his contention is that my lord, what will take she will take my lord with the money, my lord. She has a only 66-year-old father, my lord, living together, my lord.
She is not in, my lord. That much money, my lord.
Okay, go to the next circuit. Try in the meantime.
My lord, my lord, my lord, until then, my lord, stay kindly be vacated.
No, this
My
is,
lord,
this is,
my lord,
my lord,
stay-
I am paying 8,000 rupees.
My lord, they are-
I am
my
trying
lord,
for
the-
amicable settlement. This is, my lord,
My lord, the revisional application is filed on the ground.
No, my lord, this is entirely wrong. My lord, I am paying interim
What wrong?
maintenance as per the order of this honorable court.
Yes.
I am trying to
Yes.
settle the matter. Now, my lord,
No, my
they are harping upon the vacation of the interim
Yes,
order.
my
My
lord.
lord, this is not.
Yes, my lord, because my lord, their allegation is that
They do
I
not
have,
want permanent
have-
alimony,
I-
but they want monthly maintenance.
Let
My
me
lord, what
complete,
kind of a submission?
let me complete, sir. My lord, their revisional application stand on the ground that my lord, I have been, my lord, paying for 8,000 maintained in the 127 application, and my lord, the magistrate is allowed 10,000 application. 10,000 in the said application. On the last occasion, your lordship kindly show, my lord, kindly see, my lord,
That is
that
not the
I am
only
paying for 10,000, my lord. That is why the
So how
10,000
much amount you are not getting?
8,000.
8,000.
8,000, my lord.
What was the total amount? 10,000
10,000,
by the magistrate,
By the
which was
magistrate.
upon by the London Session Judge.
my lord.
So now he has challenged that order,
Yes, my lord.
enhancement of the order. Earlier it was 4,000.
Earlier was
Yes.
4,000,
4,000,
I
now
was
it is-
claiming 10,000, 10,000 has been given.
But you're working as police constable.
Yes, my lord, 46,000 he has been net pay, my lord.
Okay,
Stay
next,
kindly
come
vacated,
to the next circuit, what can be done?
my lord, stay
So-
kindly vacated, my lord.
Who has passed an order for stay? This court?
Yes,
This court, my
yes,
lord.
honorable.
By
Yes,
which
ma'am.
order? By which order?
With the first order, my lord.
My lord, kindly
My-
see the order.
My lord Justice.
It is
Subhendu-
stayed as
Yes,
because,
sir.
my lord, the 8,000 had been paid.
My lord, order dated 1st of October 2024.
Kindly see, my lord. It is stayed on the ground that, my lord, I have. been
Correct,
paid.
that is to be heard on merit. That's why
Yes.
the court, how this court, by sitting in the coordinated jurisdiction can vacate this order.
My lord, I am paying for 10,000. There is no.
Correct.
Yes,
That's
my
why the London judge has passed an order. The session judge, the magistrate passed an order 10,000. This court has considered and for the time being directed to pay 8,000. Let 8,000 you are paying.
Yes.
So you are paying the 8,000. Let the matter is to be heard on merit.
My lord, let it be hard
Next.
on merit by tomorrow, my lord. Tomorrow, day after tomorrow, my lord.
So and so appearing for the petition, so and so appearing for the opposite party. Number 2, full stop. Both the parties are also present in person. Full stop. This court has examined the wife in person, the wife is in person, but this court find that the wife is only praying for maintenance and not interested to go for the permanent alimony. Accordingly, the hearing of the case is adjourned. Let the matter appear before the next circuit.
Lord, kindly record my submission that my client is willing to get it settled.
That's why I recorded both party, but she is not interested to permanent alimony.
Lord.
That I recorded.
Lord. Great.
This is the original CD was also asked for.
Today, अच्छा that one ना कौन वाला?
CRK 6 madam.
वो record आया? Record है? Record an order. As per the order passed by this court, the Leonard additional district. The Leonard Trial Court has forwarded the case record of GR case number 683 of 2023. Let the same be kept with the record. ये मेरा चैम्बर है भाई जन
76, I have for the state, my lord.
For the petition.
yes.
This application is filed for quashing of the proceeding under section 420 and 506, my lord.
Ah.
The last petition, my lord, will recall that, my lord, was kind of to only order, my lord, that the in this proceeding, my lord, under the CRR, my lord, opposition was sought. My lord, was kindly to observe in this matter as well as the previous matter that day, that in CRR only in exceptional circumstances the opposition has to be allowed. Well, my contention is, my lord, that Malcolm is produces the complaint. This is towards the end. In their complaint, the opposite party to a self-admit there has been a certain part payment by way of cash 2 lakhs and then by way of delivering of the goods, giving back of the goods of 2,41,000. So there, by their admission, I have given 4,40,000, 41,000 so and so. But now they want it, now, my lord, kindly look at the charge sheet, my lord. On the basis, the officer in charge has said that on the basis of certain document that has been seized, and thereafter consultation from his senior, he has started a proceeding under section 420 and 506 for criminal intimidation in a commercial transaction. My contention is, my lord, that this, so far as section 420 is concerned, it does not lie because the ingredients that is required in the 420 is not attached in my case, my lord, and that this proceeding is liable to be possible. This is my condition.
Yes.
Lord, I am for the opposite party number 2. Lord, this revisional application has been filed, my lord, on the misconception that criminal intimidation or criminal offense is not maintainable in commercial transactions. Lord, the Honorable Supreme Court has categorically stated that the element of criminality has to be tested in a complaint. Just because the dispute is of civil character or of commercial character, my lord, that does not entitle it to be, my lord, quashed at the threshold. So, my lord, in the instant case, my lord, the dispute is of, my lord, almost 19-20 lakh rupees. My lord, at the threshold, they say, my lord, just to, my lord, evade from the elements of the section 420, my lord, they say they have paid some amount. That is true. 1 lakh rupees, my lord, out of 20 lakh rupees, is someone pay rupees 1 lakh and say that my intention was not to.
The civil suit is pending.
No civil suit is filed, my lord. That is my condition, my lord. And that is, I am saying that, my lord, kindly look at the charge sheet, my lord. Has there been any ground for starting proceeding under 420 and 506? There's no such ground mentioned, my lord. Only the officer in charge is saying that certain document has been seized and on consultation on the basis of the senior, 420 has been initiated. So where is the ground? Where is the criminality? Will I show that?
Yes.
My lord,
So there's no, you're not initiated any suit for recovery of.
Not yet, my lord.
Not yet, my lord.
Not yet, but.
And my lord, my contention is that.
Okay, this matter requires hearing.
Yes.
My lord, that has been
Yes.
that has
Yes.
several round of hearing, my lord.
Correct, but this court is not having time. When
My lord, I kindly appreciate one thing, my lord. On the last occasion, my lord sought for case diary, my lord.
Case studies.
And my lord only observed that this 420 in the commercial transaction cannot be, and the learned advocate of the state says that
There is a
420 has been initiated and
wants
it's
to
up to the, my lord,
the-
to decide whether or not it is liable to be proceeded with.
Invoices and
Kindly, my
everything.
lord, appreciate, my lord. The 420, then they have failed to establish their case, my lord.
Okay. Come, go to the next circuit, argue the matter.
But this will take some time, that is right.
So suffering for the petitioner, so suffering for the state. In terms of the order passed by this court dated 19th May 2025, the prosecution has produced the certified copy of the CD. Police stop. This court find that this required, this court find that the hearing will take some time. Thus, this court is not having time to hear the matter. According the case is adjourned, that the matter appear before the next circuit bench. The interim order granted earlier, when it is going to be expired? The interim order.
Not yet filed, my lord.
Yeah, of course, fine.
Wait, we have not
Given the
put out
copy.
No, my lord, cannot file, my lord. Without a copy, my lord, how
Yes,
can?
where is the can? There is no can. Nahi. Next circuit.
They says that if I say, I appreciate that the opposite party on every single instance has sought for time. They are the ones.
Correct. I am not blaming any of the
What
parties.
kind of submission?
This court is not blaming any of the parties, but today is the last. If I hear today also, how the judgment, because other three judgments are there with me. And now the but where is your extension application? 13 it was expired. 13 the matter was not taken up. Matter was taken on 19. You are not mentioned on 13.
No, matter was mentioned, but I was told that.
Yes, next.
Grateful.
Number 77.
I am for the statement.
Let all the matter go to next circuit.
It is. Stay is extended. 76.
Where is the stay? Huh? 5/3/2025 until further order, 12 weeks. 3 week at March, 12 weeks. So suffering for the petition, so suffering for the state. As
Our
per
state is
the-
present, holding the seat in.
along with the CD, full stop. Due to paucity of time, hearing could not be taken, the case could not be taken up for hearing. According case is adjourned. The interim order granted is extended till
9th, next.
till 12th of June 2025 or until further order, whichever is earlier. It is the matter before the next circuit bench.
Maybe please to take up item 78, madam.
No,
Well,
no
it had-
matter.
Well, it had on-
Next circuit.
Next.
Lordship, the only urgency is one urgency, Lordship, my senior is there.
Well, we have filed an application for interim order. My lord had on the last date directed us to hand over a copy of the general power of
Which
attorney.
one?
We have done 78, my lord.
Yes.
My lord, the anticipatory bail had been cancelled because we had not handed over the original general power of attorney. My lord, on the last occasion had directed us to cooperate. We have handed over. My lord. Our anticipatory bail has been cancelled. I am a lady having two children. The only ground on which it was cancelled is that we did not follow the direction of the learned session judge and hand over the original general power of attorney, which we have done as of now. My lord, state is there. State may perhaps indicate. My lord. So nothing remains in the cancellation. My lord.
File the 78. 78.
28. My lord, that is it.
Power of attorney the original power.
Where is the
Yes,
order?
sir.
Where is the imping order?
My lord, the impugned order, my lord, would get in the supplementary. My lord, kindly comes to the supplementary. My lord, the order of supplementary 22nd of January 2025. My lord would find that the learned session judge has stated that not on the merits but due to the conduct, the anticipatory bail is being cancelled.
Where is the anticipatory bill order?
Anticipatory bail order is, my lord, at P2, my lord, page 17 of my main CRR application, page 17.
Accordingly, concerning aspect in anticipated will granted to the present accused further petition imposing certain condition. In the event investigation case should not get hampered. Accordingly, prayer for anticipated will connection with the above information. Only in the event of yes. So this is
Well,
the
it's-
condition.
My lord.
You are not appeared before the investigating officer and you are not provided.
Within 10 days, my lord, I could not.
No.
And on the 18th day, my lord, cancellation was filed. Thereafter, there was no scope.
10th day. And who has filed an application for cancellation? IO.
My lord, IO himself, sub-inspector, on behalf of the state, there is no averment in the affidavit as to how he has been empowered to represent the state. That was also one point, but my lord, as of now, I have already handed over the general power of attorney, my lord.
To whom?
My lord, to the IO. My lord, subsequent to your lordship's order last week.
How? So I'm for the deserter complaint. This is the accused
If
was-
you handed over, but why you not been arrested?
That's true.
Grateful.
Actually, the order.
I sent a representative, my lord.
Question.
My lord, the direction was to hand over the
general power of attorney. I have handed it over, my lord.
To cooperate, the order was to cooperate with the investigation.
My lord, the IO intends to interrogate.
I also failed to understand why it was not.
Well, I have sent through a
Yeah,
representative.
the court's direction is being complied with through a authorized person. Then everybody will do it. This is the rule.
My lord, has the
I will
IO
never appear.
sent any notice, my
I
lord?
will never appear.
If the IO intends to interrogate, he can send a notice, my lord. My lord had directed, we have handed over the document. That was the only ground for cancellation.
Yeah, FIR is against whom?
FIR is against me, my lord.
What is your name?
Faranaz.
Faranaz. It's filed by my cousin saying that I had apparently forged a general power of attorney. I was granted anticipatory bail on the ground that I have not used that general power of attorney anywhere. That is not the prosecution case.
Yes. Yes.
So I'm for the defector complaint. So this is not an ordinary case of a civil nature. This is such a grievous offense that has what happened also according to the FIR. I being a public servant was engaged in a particular duty at Asansol. That lady, that accused person, has forged my signature before the registering authority on that particular date and time, and transferred my land, imposing impersonating.
I am doing today. We are on 21.
Yes.
I am fixing it the matter on 23rd, passing an order not to take any coercive action against the petitioner, and the petitioner shall appear the investigating officer and let the matter appear on 23rd.
Grateful.
So if that be so,
What you record? So she will appear.
No, my humble submission is that so far the impugned order is concerned, I didn't find, Lordship, I believe that court will not find any illegality of the order.
The court did not find any illegality.
Yes.
The court has passed an order anticipatory directing to cooperate with the investigating officer and to produce the original within 10 days. Within 10 days, it was not produced. IO filed an application, it was cancelled. Now they filed the revisional application. Now this court has passed an order, they take appropriate step. Now the IO has submitted the report, the original power of attorney has been submitted through the father, brother-in-law, or husband, whatever it may be. Correct. I am not passing any order, but I am fixing the matter on 23rd only because the petitioner will appear before the investigating officer to cooperate with the investigation. No coercive action shall be taken. That if she appeared, then okay, then I pass appropriate order. The lady, what purpose would be served by keeping?
The purpose will serve that she is not an ordinary lady. He has made 61, not on one. 61 number of plots from various persons of this. I have a list of documents.
That is not the.
I have made ready my written opposition. I would like to use it. This is an habit. She is an habit in doing so. Not one, not two, not three. She is a criminal with criminal mind. She has transferred 16, executed 61 registration of deed.
61 registered deed of
61 number of transfer.
By forging signature?
Yes.
Of the 61.
And he always try what she has always trying. Every time he approaches to the civil court, each and every court believes that this is a civil nature of case. And this is you need not to take any coercive action. She is a lady and everything done. I could have understood this is by mistake one thing done. One second, third, fourth, I could have understood. A person who is deliberately in habit to transfer n number of as many as 61, I have a recorded evidence that n 61 land has been transferred now by forging the
But
documents.
it's my learned friend
himself.
representing the
But
state.
he is maintaining two identity of herself. He is father of one person at here, Jalpaiguri, in the district of not Paschim Mednipur, say Paschim Bardhaman. She is maintaining other daughter of other father, and she is in habit to commit a series of offences. This is not an ordinary case, Lordship. Court may pass it in.
So and suffering for the petitioner, so and suffering for the state, and so and suffering for the de facto complainant. The counsel for the state has submitted the report wherein it reveals that on 19th May 2025, the husband of the petitioner has produced the original power of attorney to the police, and accordingly to the investigating officer, and the investigating officer has prepared the prepared seizure list and taken the said power of attorney, has prepared the seizure list with respect of the said power of attorney in presence of two witnesses. Let the report be kept with the record. Police. Then a counsel for the de facto complainant submits that he is having certain documents which prove that the petitioner has committed forgery against several persons, and he will file affidavit in opposition in connection with this present application. Accordingly, the de facto complaint is granted liberty to file affidavit in opposition within 2 weeks after serving the copy to the learned counsel for the petitioner. Full stop. The petitioner is liberty to file reply, if any, thereto within a week thereafter, leave the matter before the next session bench.
Grateful.
Kindly grants a stay, my lord, on the order, my lord. I'll cooperate.